Yes.
My Lordship, kindly to mention a Lordship correction. Only the name of the lawyer, the Lordship, is to be incorporated. Only the one name is there, senior advocate is missing, and one name of the second lawyer is not there.
Yes, we'll leave them. Yes.
My Lord, may I have your Lordship's kind leave to mention an application, my Lord.
Yes.
And another matter, my Lord, that is, my Lord, this matter has been moved before your Lordship on 1st of December. My Lord, there was a caveat that has been suppressed by the learned advocate appearing for the appellant, my Lord.
Well, vacating application, one-page vacating application.
The matter is returnable on 15th, my Lord. If in the meantime it could be...
and when it comes, let it come. Yes.
The applications for registration.
Yes. Yeah.
My Lord, I was mentioning a first appeal of 2018 in which direction to file paper book was passed in 2019. Thereafter, my Lord, your Lordship's bench in November 2024 extended the time for 4 weeks. My Lord, no paper book has come. My Lord, the respondent who has enjoyed the is deprived of enjoying the decree, my Lord, and as senior citizen.
Please put it as to be mentioned, Mr. Malan. Just and it will appear as to be mentioned. And give a notice to the other section.
I have given notice.
Yes.
Notice is annexed.
May I permit application?
Yes, please.
My Lord, application.
May I permit to mention one tribunal hearing matter?
Hearing no.
In connection with the Mandamath appeal, group 1.
Lordship kind leave to mention the matter. This is an appeal where an application of an interim injunction in connection.
You are mentioning the application?
Well, it's both, the appeal as well as the application.
Appeal is very difficult to add.
Then it kindly accommodates the application. The appeal is not yet listed in the, it's not appearing in your Lordship's list. So we were not sure.
It will appear under any application, then let us consider.
There's some urgency associated with the matter. Your Lordship.
Application will appear in the list.
Yes. Grateful.
I am mentioning one matter, an application.
Yes. Call it.
My Lord, I'm appearing for the appellants, my Lord. My Lord, the matter, the suit matter has been decreed on compromise matter. Your Lordship. Therefore,
don't you want to proceed with the appeal?
Yes, Your Lordship.
Right.
I've got direction from the appellants. Your Lordship, kindly.
Right. Learned counsel appearing for the appellant submits that the suit from which the appeal arises has been disposed of on compromise, and as such, the appellants do not want to proceed further with the appeal. Puts up a written instruction in that regard, filed today in court, as well as a copy of the compromise decree in the suit are handed over, which are kept on record. Accordingly, FMA 858 of 2022 is dismissed for non-prosecution in the light of the above observations. Interim order, if any, stands vacated. No order.
Deeply obliged. Deeply obliged.
Item number 2 is for release. My Lord had appeared, my Lord, for the appellant.
Oh, it is you are for the appellant.
Yes.
Learned counsel for the appellant points out that one of us, within bracket Shobhusachi Bhattacharya J, had appeared for one of the parties before elevation. Accordingly, let the matter stand released from our list on personal ground with liberty to the parties to seek an assignment before a different bench from the Honorable the Acting Chief Justice.
Item number 3.
My Lord, I'm for the appellant. You want to withdraw the matter, my Lord. The match suit was filed against the section 13 for waiving the statutory period. But the period has gone and the long period has over.
Don't want to
now I want to file afresh, my Lord.
Want to file?
I mean, if required, I want to file afresh against the divorce suit.
On subsequent cause of action?
Subsequent.
So no leave to file afresh?
At present time, here is
learned counsel for the appellant submits that the appellant does not want to proceed further with the appeal. Accordingly, FA 70 of 2024 is dismissed for non-prosecution without any order as to cost. Interim order, if any, stands vacated.
Liberty.
We asked specifically with or without liberty. No liberty.
Okay.
You did not ask for any liberty.
Yes.
Liberty means liberty on the self-same cause of action. Then we have to be satisfied why you asked.
No self-same. Grateful. Thank
you. I am.
Yes.
My Lord, I have concluded, my Lord.
Yes.
An inspection was done on his behalf.
Yes.
Before where I
stopped on the last occasion, but I want to point out another one aspect of this for this reason, my lord.
Yes.
Your lordship, I said that
this is the, my lord, list of dates lost. Sorry.
Yes, Mr. Bera.
Yeah. What it transpires, your lordship has already seen that the date of notification and date of declaration is the same. Number since 4A was not there when the original act was passed, but the notification was published, so 4A will not apply, so it can be done simultaneously. But I just want to say something, because possibly it cannot be done, because similar type of like section 4A, similar rules were there initially when it was framed. So your lordships have to consider whether it can be passed or not. But this is the original rule. Old act your lordships has, if your lordships so want.
Act gulo din ekটু. Act.
Old act.
Land Acquisition Act.
Notification and ruled.
Old act, my lord, I have already handed over.
Yes.
Yes, you have.
Have your lordships got the old first publication?
I have already handed over, my lord.
Mr. Shenmukta had.
I got that.
This is the first one.
Yes.
We already have it.
Yes, yes. I have handed.
I have also copy. If your lordships so want, I can provide.
Need not. It's already there.
Yes.
By multiple.
Number your lordships, kindly see, take these rules. Rules which was framed immediately after passing of that. That's my understanding. There are some decisions of this court. I do not want to go on to totally that aspect. But your lordships kindly has seen the scope of section 4, 5, 4A was not there.
Active copy পান না বাঁ দিকে না এটা তো রুল ওটা
Old act.
Yes.
Your lordships has seen that 4A was not there. 5 was there.
Yes.
5 preparation of sanction scheme, and 6 is the publication of declaration,
Yes.
and 7 is the emergency clause. By emergency clause, without complying section 5, the declaration can be done. Now, in this context, your lordships kindly come to rule 5(2), second page. 5(1)(a)(b) is there. I think this is in between 4 and 5.
Yes, rule 5(2).
Yes. 5. Before submitting any scheme prepared under sub-rule 1 to the provincial government, the committee shall cause a local inquiry to be held in respect thereof by the collector of the district concerned or any other officer authorized by the collector in this behalf, giving all persons interested an opportunity of making representation, if any, against the scheme, and shall record its recommendation thereof. This is before preparation of scheme. It is not the sanction scheme. Here the law says that 4A was not there. So without complying, without sanction claim, declaration can be published. But here it is before submitting the scheme, a objection is to be taken. And the committee is by section 3. Your lordships can have a look. Section 3 provides the provincial government may appoint in accordance with the rules an authority hereinafter referred to as the prescribed authority for carrying out the purpose of this act. So, rule 3, read with rule 2, but to my understanding, this is in between 4 and 5A. So, 5, these rules between 4 and 5A. Yes, 4 and 5. So, you must take objections from the landowners. Thereafter, you can frame it. And whether scheme has been sanctioned or not, that's a different aspect. Without sanctioning any scheme, you can proceed to publish the declaration under section 6, read with section 7. So, my understanding is this. So, objection is necessary before publication of declaration. That's my first submission. So, here in this case, admittedly on the same day, declaration has been published. So, my lord, it cannot be done. Declaration is bad in law, to my understanding. Then, my lord, your lordships once more, my lord, kindly come to 8 for a moment. Section 8, my lord, much argument has been advanced on side, and your lordships was all some impression about the may acquire. But a declaration under section 6 shall be. I will not take much time because since I have argued on the last only 1 or 2 sentences I want to say. A declaration under section 6 shall be conclusive evidence that the land in respect of which declaration is made is needed for public purpose. Declaration is final declaration, and after making such declaration, the provincial government may acquire the land, and thereupon the provisions of the Land Acquisition Act 1894 hereafter in this section referred to as the said act shall so far as apply, provided the possession is one is taking possession. What I submit, whatever may be the word may, shall, will, but I think it contemplates a future situation. It contemplates a future situation. Only after completion of declaration, government may acquire. Then, if acquisition is complete, then it is to be done under the Land Acquisition Act. So, at this stage, may acquire does not conclusively prove that the acquisition has been complete, even if possession is taken. But taking up over of possession is one thing, and to declare the award is another thing. And award is to be declared under the Land Acquisition Act. So, it contemplates a future situation.
So, you mean to say that mere declaration does not mean acquisition has been done?
No, certainly not. Declaration.
No, that is what you are arguing.
Yes, like section 6 in Land Acquisition Act, then it has been said declaration means the decision of the government to acquire the land is final. So, declaration is like that. This government has finally decided to acquire the land.
That does not mean that acquisition has happened.
Acquisition has been completed. Acquisition.
Yes.
So, it will be completed only after declaration.
Of course, that is the clear meaning of section.
That is the clear meaning of
definitely it has to be acquired subsequently.
This is aspect. Then, before going into the other legal aspects, I have also, my learned friend has handed over to your lordship list of dates. Final list of dates, I will submit later on.
But there are several list of dates, Mr. Bera. The difficulty is that we don't know which to follow. It will create unnecessary complications. If their list,
what I am submitting.
The dates are common, then we won't take
something is to be
so many lists of dates.
When
he passes the judgment, he finds several list of dates. Some do not tally.
Generally, your lordships ask us to submit some written notes after conclusion of hearing.
Yes, we will direct you.
But
in bullet point notes only, because you have argued.
What I am prepared.
Yes.
With reference to the, I do not know how my learned has.
No, I am handing over. My lord, only chronologically list of dates are available.
This is only list of
dates. Yes,
no argument.
List of dates. No argument. No argument.
No argument, but one document. 2 documents. You give a copy of this to him.
Yes. He also inspected.
But even then, you have handed over 2 copies of documents also.
I am giving. Right now, I am handing over. We just ওই যেটা লিস্ট অফ ডেটস এটা করলাম, ওই যেটা আপনি দেখলেন এই সমস্ত এই যে এইগুলো যেগুলো তুলেছিলেন, এই যে 50-তে যেটা অরিজিনাল, যে কোনো অরিজিনাল।
I am not objecting. I have prepared. Some comments have been made in my list of dates.
That will be written notes. You put it in a written notes. Don't file it at this stage.
To argue, it will be necessary.
You keep it with you, and you argue on that.
Kindly see this for a moment.
No, then Mr. Bera, we won't permit you to file further written notes of argument. This will be your written notes. We don't keep, because in every matter there are 10 sets of comments and written notes of arguments. We won't go through all that. One set of written notes of arguments, either you file now, or if you want to wait, you file later.
Your lordship,
argue on the basis of that.
Your lordship kindly see.
Yes.
Why I wanted to file this, because writ petition has been allowed only in respect of 5 plots covered by the declaration. So I have given the the list of dates have been prepared, but plot number have been given. Your lordship then kindly see.
All plot numbers have been given.
All plot numbers have been given.
Yes.
But your lordship's
But I should be candid. Whatever, even if some wrong is there, I have incorporated.
No wrong is there. What I am submitting in my list of dates, I have underlined the plots which were involved, that has been that is not here. But I am pointing it out. Our kindly make the mark our plots in respect of which repetition has been allowed. That is CS plot number 3074 entire. C3074 entire repetition has been allowed.
Yes.
CS plot number 3077 part.
Yes.
CS plot number 3083 entire. CS plot number 3085 entire. And CS plot number 3075 part. Repetition, the Honorable Single Judge is directed to complete the acquisition in respect of this.
No,
now,
entire acquisition was cost.
Not.
Yes.
Your Lordship has seen that. I would come to that. Repetition has been allowed only in respect of these plots, not other plots. Then, Milord, in 19th of May 1950, first notification under Section 4 of the LDP Act was published. That is for 12.40 acres. That is page 15 of the stay petition. Then we wrote plots. All the 5 plots in respect has been in respect of which repetition has been allowed, that is included here. Your Lordship can remember that or mark that. Then we wrote Section 4. Then we wrote on same day declaration for 12.04 acres were published. Same day.
So this is under Section 6.
Section 6. So these 5 plots are also included in the first declaration which was published.
Yes.
On 19th of May 1940, yes. 1950. Now, my lord, then 2 possession certificates are there that have been annexed to my land.
Yes, I have annexed.
Your Lordship kindly.
First one and second one was already annexed from my appeal. First one I have given because second one is there.
First one, kindly see, this is dated 20th November 1950. 20th November 1950, my lord. Here, my lord, 9.33 acres, not entire. 9.33 acres were included.
I have written, sir, আমারটা দেখুন, আমি যেটা লিখেছি দেখুন, আমি
ঠিক আছে,
যা আছে সত্যি কথাই লিখেছি, যেটুকু পেয়েছি অরিজিনাল এইটুকু দিয়ে দিচ্ছি, আমি যেটা লিখেছি সেটাই আছে।
Now, my lord,
all right, yes.
Then, my lord, second document
তো রিট পিটিশনই আছে।
সেটা থাকলে আমি বলছি। Then, my lord, 5th of April 1951, declaration under section declaration was published withdrawing acquisition of 4.04.
This is not here in this.
Yes, that is appearing at page 16 of the writ petition.
5th of April
5th of April 1951. That data has been given, possibly it has been given.
So 1951 is already been annexed in my stay application. 1952.
Yes, Mr. Bera, let him sorry.
No.
Yes, Mr. Bera.
Yes.
On that date, a notification was issued withdrawing certain plots.
Certain plots, 4.04
acre.
And
this is at page?
This is at page, my lord, page 16 and also at page 86. Page 16, kindly remember, he has imposed that.
Page 16?
Page 16.
All right.
Now, my lord.
Of the stay application?
Of the stay application.
Yes.
Here, my lord, plots withdrawn 3043, 3058 to 3063, 3076, and portion of 3075 and 3077. Your Lordships kindly note that your Lordships got it. Out of these,
3043, 3058 to 63,
63, 3076, And
these three plots were entered.
yes,
These
entire and part of plot number
75 and
3075.
77.
Yes. Now this 3075 and 3077, that is included in my 5 plots. So with declaration was withdrawn. Then mirror with 2 plots withdrawn, another 3 plots remain in this declaration. So that shall be segregated from that. Then Miller, on 4th of September 1951, another declaration was published stating that 8.75 acres of Mauja Belghoria comprising CS plot number such and such is required. So this is Miller second declaration. 8 point, Miller, this is 8.75 acres.
All right.
Then again, Miller, that was withdrawn from there, but again in 4th of September, fresh declaration published, 5 plots are there. 5 plots are there. So, Miller, situation is like this. Initially 12.4 all plots, then declaration all plots, then my 2 plots are withdrawn, then again fresh declaration was made, therein my all 5 plots are included. Then Miller, again 24th of May 1952, fresh possession of 8.73 acres were taken, and Miller, in that possession certificate, my all 5 plots are involved. So, Miller, then so position like this, declaration, 2 declarations are published, withdrawn. Notification remains there. That is single, always there. Initial notification is there, withdrawn, part withdrawn. Then Miller, in what I am submitting, Miller, from the records, if this situation arises, Miller, after all, it is a land acquisition records. It must be initiated from the government. Then your collector will, certain functions are left to the collector to acquisition, etc. But the order sheet of the file is not available. How this decision was changed from time to time? All those documents are in the file without any order sheet. Can it be done? Can we look? It cannot be. What prompted the government? And even in section 6, declaration, your lordship knows, under section 7, if there is real urgency, then they can take. So, whether there is a decision of taking real urgency.
Is there any requirement in law to pass a reasoned order for this declaration? Government can take that decision anytime.
No, that is
it's executive action.
Executive action, but if executive is...
No order sheet is required in law. So why should they produce any order sheet? It's their decision, internal decision, they may take a decision. That's absolute prerogative of the government.
My understanding is this, because...
Your understanding is based on which provision of law?
No, because the file must contain the decision...
May not.
Decision-making process?
May not.
Very well. I mean, I am stopping here several times. Then, Miller, kindly come to two other dates, Miller. Then, Miller, 23rd of June 1997, decision was taken, cancel notification under section in respect of plot number 3067. That is not necessary. That is not my plot.
23rd of
June 1977.
That is not here, but since you say that's not necessary, we are not putting it in.
That is possibly that has been...
If that is not regarding your plot, then we are not bothered.
Yes, so I am saying, Miller. Then, Miller, 1979.
Yes.
Press notification under published. We are not concerned with that. That is also in respect of 3075. Then, my lord, we are concerned with 8th November 1979, fresh declaration was published in respect of several plots, and that is page 19 of the stay petition, and therein my plots are also included.
Yes.
That is for, in one case, the decision was have been enclosed, but so far as this fresh declaration is concerned, here I am joining this. So many declarations are there.
Previous declaration was not withdrawn or changed or anything.
No.
Second declaration.
Second declaration.
There was a first declaration.
Yes.
There was a second declaration.
Second declaration.
After withdrawal of the first, there was a second declaration. Some of your plots were
there.
And in the third, before the third declaration, was the second declaration again withdrawn?
No.
So that also.
Yes.
The second declaration was also withdrawn, but there is nothing on record to show that.
Yes.
The fresh declaration of was made on 4th of September 1951. That is a fresh declaration. After the erratum being published on the same day, they made a fresh declaration 4th of September 1951.
Yes. Those are withdrawn. That has been supplied possibility.
No,
that is,
nothing is there in a list of date or their list of date regarding that being withdrawn.
4th of September 1951.
When was that withdrawn?
That is there. Possibly.
Sir, Sengupta, which
My lord,
date?
4th September 1951, my lord, got it. Yes.
Previous one was withdrawn.
Yes,
4th September new declaration.
and my lord, yes, my lord, kindly see the inner page 4. Inner page 4.
4,
Kindly
yes.
come. Last part, that last paragraph, declaration.
That is this.
Declaration such and such. LDF, my lord, this is number is important. That's why I have given the number.
All right.
It's very important because
Yes.
it can tally. My lord can tally with the that yes, whatever is cancelled, whatever is withdrawn, so that my can tally with that.
Yes. So
Now kindly see declaration 538 19th May 1950 under section 6 and 7 of the West Bengal published at Calcutta Gazette Part 1 Gazette 1st June, 90 page. Number 77, Calcutta. That is, my lord, 4 point something like that he was making.
that was
submission.
the previous declaration was withdrawn.
No, first previous declaration. Yes, 4
1950 declaration.
Yes, 4.70 withdrawn. Then subsequently that withdrawn was cancelled. My lord, that is 4th September 1951. Kindly see.
Acha. So
Is
4th
hereby
September
cancelled.
1951, several
that-
things happened.
Yes.
First is you publish
1st June 19. Yes.
publish an erratum regarding the previous notification.
Previous that is 4th 9 September. Then same date 4th 9 September.
New declaration.
4th September 1951. My lord, that cancelling the 1st June 1950 that he is talking about. He is making that.
Yes.
4 point. That is his plot is
That is withdrawn.
yes.
And now by this third.
Now by the third, my lord, that already is, my lord, and
The
has
third one covers the one withdrawn from the 1950 declaration. That's
some portion is there because, my lord, I should be candid to my lord because I have gone through the entire records. My lord, is very actually these records are in such a position, my lord can see, my lord, the first, my lord, the
no,
1950
we understand are in a very bad
yes.
But
So
what is the
I found, my lord, that from the records, my lord, kindly consider one thing. That the previously 12.40 acres. First, then it can come 9 point something. Then finally it come 8.73.
But it has to be reference to particular plots.
Particular
Cannot be
portion
vague.
is there. Particular parts, this portion,
What we
southern
are
end.
wanting to know, Mr. Sengupta, is
Yes.
that by virtue of this 4th of September 1951,
That is annex
notification.
page 11. Annexure I have given. It is the original one.
page 11 stay petition.
It's no stay petition. My list of dates.
Acha, no, we are not asking that.
Yes.
We are saying that at page 4 of your list of date, you
Page
mentioned
4.
the last paragraph,
Yes.
the declaration, just the one which you placed just now.
Yes.
The
Yes. 3rd
declaration
April
number
1950.
Let us complete. The declaration number 5384,
Yes.
that was cancelled.
Yes.
So is it these plots which were covered by this cancellation,
Yes.
which were freshly declared
Yes, well, kindly
on
come
8th
to
of November 1979.
well, kindly come to
Just asking you, Mr.
yes, yes, yes.
We won't
Well,
come anywhere.
yes, yes, because
So
I have
it is this.
some plots, some plots.
Listen to the question,
Sorry.
Mr. Sengupta. How can you answer
Sorry,
unless you get the question?
Sorry, I am very
Page 4, last paragraph, you say by the declaration, by that declaration, the declaration number 5384 is cancelled.
yes,
So certain plots, regarding certain plots, it was cancelled.
yes.
Are those the same plots which come regarding which fresh declaration is issued on 8th of November 1979? Page 6.
Some of the plots.
Some, but some are others.
Some.
Right. Let Mr. Bera continue. We'll have you reply.
Yes.
Yes, Mr. Bera.
So,
Please
Milord,
take up from there.
on 4th of September, Milord, the declaration which was published for 8.75 acres, Milord, therein my plots are involved. But by that, earlier declaration, first declaration in May,
Cancelled.
that was cancelled, and the cancellation declaration, that was also cancelled. The cancellation declaration subsequently made in the
When was that cancelled? Cancellation
that is there in the last para. You will also see at page 11. That is also cancelled. By this, two plot.
Page 11.
Page 11 of my lord, these list updates.
Yes. That's which now have been handed.
That is the my lord, the
That is not reflected in the list
original,
update.
original list updates. My lord, my kindly see my list updates. That is what I have written in page 4.
Yes.
That is the my lord, the original one.
That by that the first 1950 declaration was
Cancelled.
yes. 1950 declaration was not a cancellation declaration.
No. Page 11, if I read,
Mr.
that declaration number such and such, dated 19th of May 1950, under section 6, read with section 7 of the West Bengal Land Development Planning Act, published at page such and such, part 1, Calcutta Gazette, dated Ato, and read with withdrawal notification number such and such, dated 17th of March 1951, published at such and such page, Calcutta Gazette, dated Ato.
May I make one submission? Kindly tally with page 16 of my stay application.
Cancel.
Then my lord can understand. Page 16 of my stay application.
So two declarations were.
Yes, my lord. Kindly come to page 16 of my stay application. Then my lord can understand that cancellation.
First, let us understand the list of dates.
Yes. To what extent?
But in your list of date, Mr. Sengupta, you have stated that 5384 was cancelled.
Yes, my lord. Kindly come to page 16 of my stay application.
No, list of date first, it has to be.
Yes,
proper.
yes. I have written that 75. They kindly see published at page. May I kindly see cancelled declaration 19th May.
You have not stated that
First
notification
June
number.
1950.
You have not stated that notification number 3180 has also been cancelled.
31.
Page 11, last paragraph says notification number 3180-L dev dated 17th March was also cancelled.
Yes, 17
that is
March.
not in your list of dates.
Yes, 17 March relates to my lord. He is making that submission that 4.04 it was withdrawn. My lord,
This is 17th March 1951, Mr. Bera.
Yes.
Page 11.
17 March.
Page 11, 17th March 1951 is withdrawn.
Yes. That
the
is
last paragraph, last line.
Yes.
1951.
Yes.
It is not clear in our copy. That's why we were asking.
1951. Yes.
It is recorded in the document itself. That's why page 11, document itself. 17th March 1951.
No, the document is not legible. That's why we were asking, is it 1951?
51, yes.
Yes. 17th March 1951 was withdrawn.
Now, my lord, time.
No, let him complete. Yes. Yes, Mr. Bera, please continue. Please continue and finish because others are waiting. Let us finish this matter now.
Yes. Now, my lord, just 2 dates are relevant in this.
Yes, please.
My lord, first, 20th 11/1950, possession in respect of 9.33 was taken. Then again, 24th of May 1952, possessions were taken. Which one is correct?
The first one is which date?
First one is
20th of
20th November 1950. My plots are included.
Possession taken and
Again, same plots, one or two plot may vary.
Which date?
24th of May 1952, which has been annexed to the stay petition.
Yes.
At page 17, it taken. So
Right.
this is the situation. Government, what is cancelled, why cancelled, what was the result of first position, what is the result of second position, all those.
After taking the second position, that becomes redundant because position has been taken, certificate has been issued.
No, that document now, today he has annexed one position certificate in respect of 9.33. Then mirror again on 24th of May 1952. So mirror, I think these are the irregularities in the file. Possession must be taken once. On which date property stood vested? On the basis of 1950, the possession certificate or 20.
What will be the difference in your case if possession was taken in 1950?
No, my plots are included in all.
So therefore, doesn't make a difference.
Doesn't make a difference. But I say twice.
Suppose twice not taken, once taken.
So, Milord,
if your argument is accepted, it was taken in 1950.
Yes.
Either time it was taken. So now
both
doesn't make a difference in your case.
Yes. Now, this was up to the stage of 1957. Then, Milord, we have come to this court not challenging the acquisition proceeding. Now we are finding these documents from the records produced.
So what are you challenging?
I came to this court that the proceedings stood lapsed for non-declaration.
Right.
So award must be declared after. Government during this period, this was taken, they are saying it stood vested, etc. Land retained with them.
So apparently it did not lapse. Apparently it did not lapse.
Apparently it did not lapse, they are saying. But then, if it did not lapse, then if they publish successive declaration, 2, 3, then again they published final declaration in 1979.
Yes.
1979, 8th of November 1979.
Whether possession was taken in terms
after
of this?
No, not after that. Kindly note it. Whatever possession has been taken on 2 days. But so during this period, we could not find any document in the record system. That's why I am asking about the order sheet. Your order sheet has observed it may not contain order sheet. I am accepting that. But why after so many years, what are the reasons to publish a fresh declaration in 1979? Several plots are there. My 5 plots are also included there. And the learned trial judge has proceeded that because of this declaration, award has not published within 2 years. So this declaration is bad, 7 years. This is the reason. On the basis of this, the learned trial has proceeded that you restrict your claim in respect of 1979 notice that is disclosed in my writ petition. And writ petition has been allowed in this context. Now we are coming to the point legal aspects. This is the factual aspect.
Was it their case before the writ court, Mr. Bera, that possession was taken prior to this declaration being published?
No, they have not said anything in the writ petition. In the opposition, they rely upon one estimate. My learned will accept that is not the award, whereby 80% estimate.
That was the initial estimate.
But that too after all these in 1955. Or after this.
But if 80% estimate was paid, then the trappings of that, then the property vests at that point of time. Then that presupposes possession was taken then. Because as per Section 17(9) LA Act.
Yes. But I am.
Therefore, then property vested, then nothing could lapse. The proceeding would only be available for compensation, for calculation of award then.
Calculation of award. But
so the finding of the learned trial judge that it has lapsed cannot be a correct finding. Are we clear to Mr.? We are clarifying.
I understand. But I say, since 2 possessions are taken, it may vesting. I am coming to the point of vesting.
Even if 1 possession is correct, then 80% payment was admitted.
Ad hoc compensation.
Ad hoc compensation and payment was admitted.
Admitted. Then admitted.
Ad hoc compensation read with possession means that property vested at that point of time under
I am
Section 70.
understanding that payment has no relation with this. With the relation, with respect to taking over of possession. Law does not prescribe when you have to pay a compensation, but they paid, I admit. In my writ petition, I have also admitted. Those documents are only in the trial court, those documents are relied upon. Award has been passed, payment has been made, only balance 20% is there. But court held that is not the award. So you have to reply 11A will be applied.
Did the court consider this 80% rate of payment and possession? What was the finding of the court on that? Let us see that.
I relied upon some judgment.
No, let us see the findings actually.
Yes,
23rd of August. That is the date.
Judgment.
Judgment. Yes, that is it. Subsequently, Beleghata, Belghuria, that change was made.
23rd of August 2024.
Yes, Mr. Bera.
Page, my portion.
Refer to the internal pages, Mr. Bera. We'll follow the internal pages.
Your stay petition I have taken, or your lordships can take.
Follow the internal pages.
Internal,
at the bottom, then that will be
page
here. Yes. Page 3, right.
My submission and what is my
Exactly.
that I am skipping it over.
Right.
It will be 80%.
Right.
There are 5. Mr. J. Learned advocate appearing for the state severely disputed the contention of Mr. Bera. He contended the since notification under Section 4 and declaration under Section 6 of 1948 Act was made, and the original owner, the petitioner, and the Onukul Chandra Ghosh was paid compensation. It put the clarified.
Yes.
Submission. Number 80, Onukul Chandra Ghosh was paid compensation to the tune of 80% of land value, and the acquisition proceeding did not lapse. The further content of the writ petitioner are only entitled to balance compensation to the extent of 20%.
Paragraph 12, my lord, page 5 and 5 of.
Let him complete, Mr. Bera, please continue. Don't stop. You are placing the judgment. We cannot wait indefinitely. Yes.
Heard the learned advocates for the party. My submission has been recorded. I am skipping it over. Records reveal their notice dated 11th of January 2013 in Form A was issued under 1948 Act to the occupiers of the land and other persons known to be believed to be interested in it, or to be entitled to act for persons so interested. From the said notice, it is evident that 4.950 acres, that acres more or less of land situated in Mouya Beleghata jail number such and such under PS Varanagar in the district of North 24 are to be taken by the government for settlement of immigrants under 1948 Act, and declaration under Section 6 was published on 1st May 1980. Second. Further appears
1980 also there was another.
That they have stated in the notice, that is in the notice it is stated. My Ranne Judge is referring to the notice that is appearing at page. At page 125 of the state petition. This is the notice.
That was not a declaration under Section 6, was it?
It has been referred to in the notice that the declaration was published on such date. I have typed copy. Next page, your lordship, it is
so not. So the 1/5/1980 is not Section 6 declaration. On 1st of May 1980, no declaration under Section 6 was published.
Notice জানাচ্ছে আপনার interest কত?
Notice it has been mentioned. There was at that time the original. This is the notice it has been mentioned that What has happened in cases, documents have been filed, but the gazette notification, in some cases gazette has been filed, and in some cases gazette has not been filed.
মুশকিল হয় একদম অ্যাসিস্ট্যান্স পাচ্ছি না দুজনেই ফ্যাক্টস এলাম তখন কিছু আমি আমরা কি করি রেকর্ড করতে পারবো
It was stated in their notice that has been referred to by the learned judge. Before the learned judge, all these documents are not there. This was the notice served upon me, upon the client, after contempt application was served upon them. What has been written by the government, this date of declaration under section 6 is 1st May 1980.
That is obviously erroneous.
Yes.
1st May 1980, how could, what is the date of this? 2013.
Mirror, I am trying to tell you.
Where is the section 6 declaration dated 1st of May 1980? This only refers to that, but you don't find from the records any such declaration.
Their communication is
Wrong communication. Oh, it was published in the Gazette on
yes, published. Date of declaration is 8th November 1979.
Contradictory. Their own this is.
But the Gazette, top page of the Gazette is not here when it was published. They said it was published.
So they are referring to the 79 declaration.
Yes, they are that refers to declaration dated 8th November 1979.
Well, let us proceed from there.
Further appears from the part were involved. In course of hearing of the repetition on 19th July 1924, Mr. Vedas restricted his claim of compensation in respect of the affected plot solving. We claimed several plots we are due, but since only 5 plots are involved in this notice where it has been said fresh declaration has been made, as your lordship sometime proposes, we accept that. We accept it. The issue that calls for consideration in the question whether the acquisition proceeding initiated by issuance of notification under section 4 of 1948 Act and declaration under section 6 of the State Act has elapsed. The 1948 Act does not provide for a time limit within which collector shall make an award. Section 8 of 1948 Act states that after making declaration under section 6, the state government may acquire the land, and thereupon the provisions for the Land Acquisition Act shall apply. Section 11 of the Land Acquisition Act 1894 was added to the statute in September 1984. Section 11A84 Act provides that the collector shall make an award under Section 11 within a period of 2 years from the date of publication of the declaration, and if no award is made within the period, the entire proceeding for acquisition of the land shall lapse. The proviso thereto states that in case where the same declaration has been published before the commencement of Land Acquisition Amendment Act 1984, the award shall be made within a period of 2 years from the date of commencement. In Ajimon Bibi case Supra, the declaration was published before the commencement of Land Acquisition Amendment Act 1984. The Honorable Supreme Court, after noting the amendment, came into force from 24th of September, held that in terms of the proviso, an award in respect of the acquisition in the said reported case could have been made till September 1985 latest. The Honorable Supreme Court, after noting that no such award was made till September 1986, at that time, even thereafter, till 2011, held that the net effect is that the entire proceeding commencing for the publication of notification under Section 4 and the declaration under Section 6 had left. Now, turning back to the fact in hand, the court find that the declaration under Section 4 and was published on first in the light of Section 8 of 1948 Act, the provision of deadline under Section 11A shall be applicable since the declaration has been published on 1st of May 1980. that is before the commencement of the land acquisition amendment Act 1954. The said award also had been made with effect of 2 years from the commencement of the land acquisition Act, which came into force on 24th of September 1984. In the case on hand, no award was made within a period of 2 years from the commencement of the LMA or at any time thereafter. This court has therefore held that the entire acquisition proceeding commencing upon the publication under Section 4 Act and declaration under Section 6 had lapsed. Since the entire acquisition proceedings to left by operation of law, the payment of compensation to the tune of 80% land value to the original the land in question is of no relevance and cannot take the lapsing of such proceedings. It is not disputed that the lands of the petitioner have been utilized for the purpose for which the declaration under Section 1948 Act was published. Therefore, the state should be directed to take steps and initiate first acquisition proceeding according to the relevant statute to determine the compensation. It is, however, made here it is not award, it's not so relevant. This is the
when was the payment made? 80%. When was the payment of 80% made?
55. I am telling you last
1955.
Which is at page 12 of my list of dates. The actual owner, original owner, he died. They are the legal.
that you have been told to me
It
that
is
is
his
that page.
own handwriting. This is the original one.
That document they have disclosed that is at page 24 of the state petition. That is in date is that is on kindly come to the one endorsement you do page 29 Miller 31st March 1954 possibility check number. Check number dated 31st March 1954.
This covered these plots mentioned
Yes.
covered all your plots.
Right.
If possession was taken and compensation was paid 80%, then the land vested. The further declarations and the further notifications all become ocious.
Mirror.
Nothing remained only apart from the assessment of the award. Nothing remained but the assessment of the award for assessment of the compensation for the award. Because if possession was taken
Yes.
in 1957,
No, not 57, 51. 51, 50.
51, 52, which was admitted in 57, then Mr. Bera, nothing remained because the land has already vested in terms
Land
of.
vested on taking possession.
Yes, but
that has no relation with the payment of compensation. This is not the award.
no, but then they have to pay. They have to assess the award, compensation, total compensation,
That
and
is
pay
not the-
20%.
That is not the award. They have to declare the award.
It is not the award. Who is saying it is the award, Mr. Bera? Why should he say it is the award? 80% is when at the time of taking possession, they are required to pay 80%. Is that 80%?
No, that long after taking possession, that has been paid.
You say 1951, 52,
No, payment is 54.
54.
Yes.
But you took the possession. Now can you resile from that position?
No.
You have taken the possession. Your predecessor has taken the possession.
Not in possession. My question is taking over of possession is illegal. That I will come to later on. If taking over of possession is illegal, then 11A will apply.
Yes. If it is illegal, then 11 applies.
Then 11A apply. That's why now, my lord, I am coming to the state case law. Your lordship has repeatedly said that.
But that 80%, then you have to return with interest. Mr. Bera, we'll direct you to that will be adjusted from.
Adjusted with interest. Not 80% only. I am saying what has not been stated. By virtue of interim order, balance 20% with interest has been paid to us. That shall be adjusted with the awarded amount.
Has been paid to you?
Yes. Interim order was there. This court directed. In the meantime, you pay 20% without prejudice. Order was there, your lordship can find it from the order. So far, according to estimate, not on the basis of any award.
Why do you say, Mr. Bera, that possession, now let us come to that. That possession was illegal?
Possession was illegal because
it was not under any provision of law. Neither under Section 8 of the Land Development Act.
Land Development Planning Act.
Only Bill, Bower, and all those. This is not that. So this could not be under this act.
Or no decision is there to that. These are the lengths. Before taking possession,
there is nothing on record to show that Bill, Bower, or it was under that category.
Nothing on record to show. You cannot take possession without deciding that.
Till date, the records of right, are they reflected as Bill, Bower, or any water body?
No.
They are shown as land in the records.
Maybe some land, but that decision must be there. Various categories. Suppose a bagan, it may be fallow or it may be cultivable.
No, but Mr. Bera, why shouldn't there be a presumption of correctness? If Bill, Bow, tank, or other watery area only. All these are watery area.
Whatever may be recorded in the records of right.
What are the records of right reflecting? Because records of rights, are they reflected as water bodies?
No, records of right, I have destroyed. Some.
Are they reflected as water bodies?
No.
Yes or no?
No,
it's a yes/no question.
Yes, no question. Some plots may, according to me,
no, not according to you. According to the records of rights, what is the position?
Records of right, some may come under that. That's why I have disclosed in my records of right. Thamar, Sali, Bagan, Pukur, Bagan, Danga, etc.
So there are other types of properties also.
Yeah. That's my records of right.
So therefore, this could not be under Section 8A.
Yes.
Nor was any notification under Section 17 read with 9 ever issued. Because the Section 6 has to disclose that it's under 17.4.
It can be a various stage. In the declarations, it can be mentioned.
It is not their case even that this is a Section 17 read with Section this 6. So in the Section 4 notice, it had to be disclosed.
The records before taking possession.
This is not an urgency provision under Section 917 of LA Act. Because it's not their case even.
Not their case.
So therefore, that 80% could or possession could not be taken under Section 17 or 9 of the LA Act.
LA Act.
Only could be under 8A.
8
but then also you say there is nothing on record to show that the entire property was water area. Therefore, this possession was bad in law. So you are liable to return whatever you have got. But they, as the learned single judge held, and fresh acquisition because they have already utilized the land. So fresh acquisition proceedings and fresh calculation of compensation. What should be the act applicable according to you?
According to Act of 2013 Act, if a lawsuit on this issue, that without specifying the category of land, you cannot take possession. One single bench judgment, Allahabad High Court, I can.
Please cite it. Please cite it.
Judgment group paper. Judgment group paper. My lord, your lordship will pardon me.
Do what?
Your lordship
can't permit unless you know to do what.
Since I am taking time because lordship, I have
no further time. We have to close our.
I may take some more time to argue to complete me. I will complete it.
Absolutely, you are in.
So, my lord,
time for what purpose?
I am just.
Just cite the judgment. What else is required?
But I am just indicating 3.
We have to come to a conclusion sometime.
Yes.
Cannot go on and on.
3 points I will argue. First of all, he has this for possession. I am saying. Secondly, my lord, I have cope up with the my lord. I have to give answer to the point of waiver taken. Waiver taken.
Regarding this receipt of 80%.
Late moving of the retribution.
No, whether there can be waiver against statute, that's questionable.
Various judgments I have relied upon. If your lordship, I will.
On for what purpose? There cannot be any waiver against the law. Judgments are required for that.
And your last submission, I would submit before your lordship. Suppose your lordship hold that everything is okay. Right, your proceeding did not lapse. Still, then your lordship asked me on the along with my Mr. Justice Kumar said that nothing remains. Or it will declare on the basis of notification under Section 1950, which has been published. If everything is okay, no other alternative. Only that award on the basis of 1950 notification award is to be declared. But
now that has lapsed.
Now but still then, there is judgment of the Supreme Court has said that you cannot remain silent sitting by making a notification under section 4. You have to shift the date of notification for assessment of compensation. Because when section 4 is published, it takes the value so far valuation is concerned. But
no, but section 4, if you go by that 1950 notice, then it has obviously lapsed.
Obviously lapsed, but suppose for the argument
that it has not lapsed.
Say the
All right,
everything survived. Till then, my submission, last submission would be that on the basis of that, valuation cannot be determined, it must be shifted to a reasonable date. That is the latest Supreme Court judgment. That will be my last submission. So
the valuation should be at the current rate.
Yeah. So, no. Your loss.
At what
no,
rate? Then valuation has to be.
Discretion has been given to your lordship without remanding the matter. Your lordship must exercise your judicial power under section 226. Suppose 1950, 2010, 2008, whatever your lordship thinks that according to the your lordship.
But what should be a reasonable date?
There
should be some yardstick. It cannot be arbitrarily fixed by us.
There is no yardstick. It may be 1st May, 1st June, 30.
That the Supreme Court can do under 142. We don't have Article 142.
Therein, yes. Supreme Court has said in that decision, last decision which is coming, that I am exercising my power under 152. But prior to that, High Court, without doing so, the order has been passed. High Court has ample power to do that in 226.
Power, High Court thinks High Court has ample power. Supreme Court also thinks, but there has to be some objective yardsticks for fixing the date. We are not. We are not a great stickler of, procedure. But there has to be some transparent yardstick that we are deciding.
That is not there.
We are believer of reasons. We have to give reasons for why we are fixing that date. You cite the judge.
Well, this is first of all, Allahabad, I am submitting.
Allahabad.
Para 16. Wait, yeah, 1957 Allahabad, page 816. এটাই নোটটা আমাদের একটা কপি এই আমার নোটটা দাও আরে আমার নোটটা কোথায় গেল আর্গুমেন্ট নোট হয়েছে প্যারা 16 and 7
এটা তো
57 টা Allahabad where हमारे बांडिल জয়সালকে আগের দিনে দুটো বান্ডিল দিয়েছিলাম ডিপার্টমেন্টের বান্ডিল ফাইল করে এরকম ফাইল করে ফাইল করে
How is the collector to specify? There is no scope of any passing any order. Who will specify means what does he specify?
Specify that these are the lengths, bill, bower, etc. and so possession should be taken.
Where does he specify? In the declaration itself?
Anytime after either in the section 4 or in the declaration or.
But at the same time, these judgments.
Before taking possession, they must. Or in the possession.
But at the same time, this judgment says the nature of the land need not be specified in the notification under section.
Yes, it is not necessary. But in the.
Where will he specify then?
Possession certificate.
Possession certificate is post facto. Before, after declaration, and your judgment says this is a contradictory judgment, Mr. Bera, with utmost respect. The collector, before, however, taking actual possession, will have to specify which portion, according to the collector, was arable and wasteland. Yes. If he has to do that before taking possession, if you say it has to be reflected in the certificate of possession is issued post facto. That is not a pre-possession adjudication.
What mirror?
Judgment says collector, before taking actual possession, will have to specify which portion. Yes. So it certificate of possession is given only after taking possession, at the time of taking possession.
Before
so that cannot be. How? Where? Under which provision? What would you do? No. Paste it in the newspapers?
No. Not the section says you
This
can-
judgment, with utmost respect, Mr. Bere, is contradictory, because we don't find any provision in law whereby the collector first of all is required to specify. And suppose we accept this judgment, yes, this is reasonable.
Yes.
But where does it specify? Section 4(6) notice he need not.
No.
That is this judgment.
Then there
Before possession, where is the opportunity of the collector to say? There is no provision of passing any further order. 4(6), possession taken, and then certificate of possession. So before taking possession, he has to assess. Then we'll construe under section 114 of the Evidence Act that this is
What
duly
I am
done.
saying,
Official act.
your possession, in order to take possession, an order is required to be passed. A decision is to be taken. That's why I am saying that everything is absent in file.
We don't find any scope of any such specification. Where does it specify?
The file itself, before taking possession, they must decide. These are the nature of lands we take.
All right.
Suppose what I am submitting, suppose none of the land comes under this category. Can they take possession? They cannot.
That is your onus to show that it does not come. Otherwise, presumption of correctness to official acts is attached.
This case, we don't know. I have shown to your lordship, Rule 5(2), nothing has been served upon that except this possession certificate. Prior to that, we have no knowledge.
Very good. The next judgment, Mr.
Next judgment, according to me, on the basis of this judgment, the possession was not properly taken, so 11A will apply. So, your lordships, kindly, I have given the bundle of judgments. Your lordships, kindly see first judgment. I think possibly your lordships has observed that, find that, but 2022 SCC online SC1 408, that is Delhi Earthquake Service versus State of UP. That copy I have given, handed over to the bundle. Your lordship, first judgment.
কি করছেন এখানে? Yes.
Now, your lordship,
কিছুই করছে না, দাঁড়িয়ে আছেন বসুন। Yes.
para, entire para I will not read, kindly.
Which para?
Kindly mark. Para 1, 2, 3. Then your para 8. I am reading para 8.
Yes.
In the light of the contention, the following question arises for our consideration: is the requirement requirement to tender payment of 80% of the estimated compensation contemplated under section 3A mandatory to ensure absolute vesting of the property, whether requirement to pass the award within the time frame contemplated under section 11A applicable to an acquisition notified under section 17 of the 1894 Act. This is in the context.
This is in a different context.
Different context, while they are differing with the decision of Satyendra Prasad Jain.
So why are you citing Airtech, Delhi Airtech?
Delhi Airtech I am serving. Their possession taken is illegal. So 11A will apply. Your lordships kindly come to then consider. Entire judgment will take time,
No, where it has been said, possession was bad and therefore.
I say, that before taking possession, land was not specified.
No, why this judgment? Why in this judgment it has been made?
Yeah. I am just coming to this. Your lordship should consider those paragraphs and 8. Thereafter, para 19. I will read the concluding para. 26 and 27. Ultimate findings. The decision in this case, based on the principle of serial diary, it arises for consideration in any other cases under 1894 Act or any other enactment relating to the land acquisition containing perimeter provisions shall be applied only prospectively and cases which have been attained finally. In the result, we pass the following order. The provision contained in section 11A of 1894 Act shall be applicable to cases in which the acquiring authority has not complied with the requirement of section 3A of to section 17(3) by tendering and paying 80% sum of the estimated compensation before taking possession. And since possession in such cases cannot be considered to be taken in accordance with law, and the vesting is not absolute.
No, here it is on a different question altogether. It's the reverse. If while taking possession under section 17(3)(a)
Yes.
is not complied and the compensation 80% is not paid, then it will be a bad possession and 11A
That
comes
is
in.
in the context of Satendra Prasad Jain. This was
Whatever context, this is the ratio held in
case
this
is
judgment.
considered after 1984 Amendment Act. But the principle will be if the last sentence, since possession in such cases cannot be considered to be taken in accordance with the law, the vesting is not absolute.
If 80% is not paid, in your case 80% has been paid, it is on a different proportion. But please see too, if the requirement is complied and possession is taken after tendering paying 80%, which is your case, though there is no need to pass an award and pay the balance compensation within a reasonable time, regard of 11A will not apply. So as to render the entire proceeding bad, right of land loser in such case is to enforce precisely what we said, Mr. Bera, that if possession is taken by payment of 80%, then it was argued by the state in that case that this will lapse. Then you will not get the award.
Earlier,
That was, this is the final position.
This is the final position.
Then what happens is, if that 80% is not given, while taking possession under 17(3)(a), possession is not under section 17, not a valid possession. Therefore, it's a regular proceeding, acquisition proceeding. 11A applies, acquisition process lapse. If that is paid, but award is not passed within 2 years, then here it has been held. We are not saying it. Then 11A won't lapse the proceeding, because otherwise the dichotomy would be they have taken possession, acquired, but the land loser does not get the money. So therefore, it will persist for the purpose of calculating compensation and making the award. In your case, 80% has been paid.
That is subsequently, not prior to taking possession.
You have accepted the money.
But this judgment, to my humble submission,
This judgment does not come to you read in any manner. Here it's a reverse case where 80% was paid.
It is a case certainly after 1984 Amendment Act came into operation. In
all cases after 1984 Amendment Act, you need not cite, Mr. Bera. Only cases which are relevant, please. This is not at all relevant for your case. Sorry.
Then, Miller, on the point of
you have cited Satendra Prasad Jain. Why? For the same?
No, to compare that.
To compare? Why should you compare?
No, what was decided in Satendra Prasad Jain and what has been decided here. Only for that reason, what was decided that has been reversed. That's why I have given Satendra Prasad Jain.
Reverse. So distinguish. Satendra said once possession taken under 17(1), government cannot withdraw from acquisition.
Irrespective of payment, possession.
Satendra actually goes against you. Here, once possession is taken by them, they also cannot withdraw from the acquisition.
Why I am giving Satendra Jain Mirror has been distinguished by this.
In a limited context.
In a limited context.
Where money was not paid.
Yes, money was not paid.
Therefore, Satendra Jain principle remains. Satendra Jain principle is that if they had made the payment, they cannot withdraw.
I am saying if
both of these go, rather against you.
Miller, if possession is not, my submission is, kindly note that your lordship will consider that. My submission is that if possession is not legally taken, then Miller vesting becomes illegal. Here in my case, possession is not legally taken according to 81B specifying the nature of land. So possession taken is bad.
These are not judgments for that proposition. And what about Ramchand and others versus Union? You have cited several judgments. Why this?
Ramchand and others. Yes, Mirror.
That is 1994 1 SCC 844.
All on the point of waiver. All on the point
Which
of
paragraph?
Ramchand, para 16.
Para 16. Let us see para 16.
Para 16.
It was said that delay does not defeat the equity in this case. Having waited for more than 14 years without invoking jurisdiction under 226.
Your lordship read the entire
Para 16.
Yes. Your lordship can read me.
This is regarding delay. Delay has to be considered along with the inaction of the part of the authorities.
That's why.
We are not saying your 226 is time, but definitely not. We are not closing you on ground of delay, because we also agree with this fully. And we have held in other judgments also, Mr. Bera, that this is not a money claim simpliciter. If the responsibility, in your case also probably you have heard, that if it's the responsibility of the state, something to do, they don't do it. It's not your onus to go and claim within 3 years money claim. That bar is not.
That is the all decisions I have cited.
But this is, whatever decisions you have cited here.
Yes.
You have a common bunch and you use that in all the matters. Now we are understanding. This is not at all relevant. We are not saying, who is saying?
Very well, Mirror, then Mirror, your lordship, all the judgments I have given.
What are the rest of the judgment? Let us see.
Then Mirror,
We are in a process of elimination now. Why you have cited Tukaram Kana Joshi?
on the point of delay. Delay in moving the petition. I will note that. I will, in my written notes, I will give the paragraph.
Vidya Devi also delay.
Sukdatta is also delay.
Sukdat also delay. What else on delay? Everything else on delay.
Yes, math unreported judgment also delay. Then Miller, all those on delay.
No, delay we are not even closing.
Very well, Miller.
All of these are Ajiman Bibi also on delay.
No, Ajiman Bibi is.
Yes.
Fine.
What is Ajiman Bibi?
Why? Come to pair 9, 10 and 11. I am not reading. Your lordship, kindly repeat this. Your lordship first 9, 10 and 11. আজীবন বিধি on 11 লাস্ট এবার এটা বের করো তো আলাদা যেটা আছে বান্ডিল কোথায় আছে না না এই দেখো এটা
This is on 11A. 11A validity was held.
11 on 11 you will apply.
This is also not applicable to your case.
Review
There is no dispute regarding applicability of 11A otherwise if the position is not valid. And this Ajiman Bibi went to up to Supreme Court, that has been also. And a review also on that, no?
And curative petition also. This is all.
So none of these judgments are relevant. We'll impose cost personally on you, Mr. Bere. You will treat us to a cup of good coffee from Starbucks for this. No, from Starbucks.
Starbucks. Sir,
Not from this CCD. Starbucks. You will personally treat us to a cup of coffee, as well as to the juniors sitting behind, because they have been listening with intent.
I am always ready.
That we know. That we know. That we know. After we attain the age of 62, then you will treat us to this. Please remember that.
I will remember. If I survive till then.
Oh, you will survive. Don't say that. You will have to survive for the land losers at least, if not for us. Who will they go to? But you say position is a very good point. We'll ask Mr. Sengupta on position.
Yes. Then Miller.
Yes.
That copy I have not.
I mean, position not legally taken, that point.
2025 7.
On what point? First tell us on what point.
I am doing 100. Last 2025 7 SCC 580. Your lordships, kindly note down the paragraphs.
Yes.
Your lordships will consider. I do not want to waste your.
No, please tell us paragraphs.
Paragraph 2, 25, 26, 27, 28, 38, 39, and 43 to 43 to 50.
What is the
Sorry,
proposal?
43 to 51, then 53, 57, and 58.
সবই তো করি।
Mr. Bera should tell us the paragraphs which we should not look into. That will be shorter.
না 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 আপনারা কি বলেননি স্যার, আমাকে বলছি।
We are telling you that you should tell us the paragraphs which we should not look at. That would be shorter. No, but if it's necessary, definitely we'll go through. What is the proposition here, Mr. Bera? Shifting or postponing the date of preliminary notification.
Some of the very proceedings there. What it starts from Ramchand case, your lordship said para 16. The position is this, that section 4 notification published for public purpose or whatever.
Public purpose.
And the proceedings go. But after publication of section 4, government sit tight over the matter. In Ramchand case, in 1960, possession was taken, nothing was done. Ultimately, in 1980, the petitioner in Ramchand case, he had not there, moved the High Court. High Court say you cannot do this. You cannot remain idle for so many years, because ultimately day-to-day valuation of land is increases. So what value could be achieved in 1950 that have been paid at that time, the land loser would have been benefited. You set a date for fixation of valuation and then wait for indefinite period. In that case, no date has been mentioned, but the valuation was certain more compensation was directly paid in Ramchand.
So delay in making award to agriculturists with rising inflation, delayed payment may lose all charm and utility of compensation.
Here
Therefore,
case,
subsequent date should be
in this case,
yes.
Only your lordship should kindly see. Here in this case, same principle. What happened? Property was taken in 2002. Possession taken, nothing was done. Ultimately, in the meantime, government took the decision of the Advocate General, who said that you cannot fix the valuation on 2002. You must shift the date to some subsequent date. Learned Advocate General said make it on 2009. Then the compensation was assessed. There was requiring body. Requiring body challenged that according to the opinion of the Advocate General, you cannot shift the date. Ultimately, Miller went to Supreme Court, award was set aside. Then Miller's second round of litigation started when the second writ petition was moved by the landowner. Landowner, Miller, the High Court said that on the basis of Advocate General's opinion, you cannot fix the valuation, so it's good. On the ultimately, this matter went up to Supreme Court. Division bench also upheld the decision of single bench. The Supreme Court in this trial, very recently it has held. No, this High Court, without relegating the matter to the collector for declaration of face award, also ought to have fixed a date on which the award should have been declared.
Mr. Bera, you made one submission during your arguments that the rates should be ascertained as per the 2013 Act.
Yes, that point I missed.
But there, Mr. Bera, we are telling you something. Yes. Under section 24, if the initial act is complete your thing, then we'll.
No, I have a complete.
Under section 24 of the 2013 Act, Mr. Bera, if it's a proceeding initiated under the LA Act, then only award can be given if award is not passed when this act came into force. Then it will be under the 2013 Act. But this is not a proceeding initiated under the LA Act. So simple question is, how can this 2013 Act apply at all?
There I am joining the issue. Number with effect from 1st January 2014, the Land Acquisition Act is no more there. This proceeding initiated under Land Development Planning Act. Ultimately, without the aid of Land Acquisition Act, award could not be made. Even if your lordship say that
Understood. You are trying to extend
Yes.
because Section 8 itself says after this land acquisition act.
Suppose land acquisition is no more there.
Mr. Bera, there is one difficulty because there are several judgments of the Supreme Court which say if it's a legal fiction cannot be extended beyond its scope to create a second legal fiction on the superstructure of the first one, on the basis of the first one. First legal fiction is this 1948 Act says that after this stage, LA Act will apply. This is the first legal fiction because LA Act is not imbibed in the statute. It said the provisions of that will apply. This is a legal fiction.
Yes.
Now the second legal fiction will be by virtue of this applicability of LA Act, it should be deemed to be an initiation of an acquisition itself under the LA Act. But that will be a second legal fiction.
Second legal. But what I am saying,
we can apply the Section 23 yardstick of LA Act. LA Act is not there because we are doing justice, substantial justice ultimately.
But your lordship will consider this that second impression. What your lordship use the word?
Second legal fiction.
Second legal fiction. The position as on today, your lordship kindly read only 24(1)(a).
1A says that
1A.
acquisition under LA.
No, it starts with the proceeding initiated under the LA, and if the proceeding remains or proceeding survives.
What proceeding? Which has been initiated under the LA.
Under the Act.
Then,
but it is to be completed under which Act? Under the Land Acquisition Act. Land Acquisition Act is no more there. So, Miller 24(1)(a).
Land Acquisition Act no more there. Mr. Bera, Land Acquisition Act is no more there is not a factor here. Because 2014 Act, whenever the 2013 Act came, Land Acquisition Act was no longer there.
Yes.
Therefore, one legal fiction is
was there, but it
was there for limited purpose.
But
Section
certain remains survived by subsection 114.
Exactly. So therefore, the first legal fiction is that it will be proceedings initiated under the Land Acquisition Act will be continued under this act, the assessment for the purpose of assessment. So this is a legal fiction. If the acquisition is under the LA Act,
legal fiction is there. So ultimately, if award is required to be declared, if in respect of a proceeding initiated under the Land Acquisition Act, then if it survives as on the date of commencement of 2013 Act, then 24(1)(a) will be applied. Compensation is to be assessed under the provisions of 2013. This is the situation. This is the plain meaning of section 24(1)(a). Proceeding must be initiated under the Land Acquisition Act, and if it survives as on the date of commencement of 2013 Act, then the assessment is to be made under the provisions of Land Acquisition Act. Yeah,
so,
2013 Act.
So got two primary arguments. One is possession is not legally taken. That is your first argument,
yes,
which cannot be waived.
Yes.
One. Secondly, if that argument is accepted, then it has lapsed, and 2013 new acquisition proceeding justice the learned single judge is justified. Secondly, you say 2013 Act should be applicable, read with this judgment.
Yes. Yes.
Subsequently.
Second aspect is, your lordship, kindly for a moment look 24 for a moment to my
Section 24. Yes, you can read out. We remember.
Well, where now we can, notwithstanding anything contained in this Act, in any case, land acquisition proceeding initiated under the Land Acquisition Act, where no award under Section 11 of this said Land Acquisition Act has been made, then all provisions of the Act relating to determination of the compensation are applied. So award is required to be determined under Section 11.
But it starts, the section starts with in any proceeding initiated under the LA Act.
Not dispute.
So how can you make this argument even, Mr. Bera? You are sufficiently senior for that. If the section starts with if any acquisition is commenced under the LA Act, then everything else follows. It refers back to that.
It is to be determined under the LA Act.
This is not a proceeding initiated under the LA Act.
But ultimately it is to be determined under the LA Act.
To be determined under the LA Act because of the 1948 Act under which it was initiated.
LA Act. Now, if 19 Land Acquisition Act is no more.
By virtue of 1940.
My submission is.
No, Mr. Bera, by virtue of 1948 Act, just because certain provisions of the LA Act regarding calculation of compensation are applicable, that does not mean the acquisition becomes an acquisition under the LA Act. No. Acquisition remains under 1948 Act.
I am not saying so.
A 1948 Act itself says some provisions of the LA Act will be applicable. That's a legal fiction.
Legal fiction.
Now, therefore, it never becomes an acquisition under the LA Act.
That's right. But since it speaks of that,
it says if an acquisition is start,
LA, section 11 of the LA, that's why
that is not much acceptable. So, Mr. Semyukta will hear you after 10 minutes. We'll come back. We'll hear you on this, particularly this question, whether the
Position was not legally
that is the
taken.
main point which it was.
Yes, my lord, I will answer.
Two questions. One is that position not legal. Why? Because not bill, bour, nothing is reflected. So 8A could not be applied. If it is not 8A, 17.4 read with 9, there is nothing on record to show it was a 17 acquisition.
I follow.
and mirror that.
Come.
Our
ডিস্টার্ব করলাম না, সেখানে গিয়ে গোছাতে হবে।
Yes, yes, question.
My lord, I have already completed my submission.
Yes, yes,
I
only
think, my
rejoin
lord,
back to this.
I do not want to make any further submission, 7 except what my lord,
Position.
yes. My lord, only one thing, my lord. First, my lord, whatever judgment he has relied upon regarding position when to be treated as an illegal one. All those judgments I have gone through, my lord.
Money not paid.
But my lord, yes, my lord will see, my lord, that all judgments relates if it is not acquired.
All right.
If it is not acquired, acquired means, my lord, as per Land Acquisition Act, only 17(1), if it is invoked, then before passing of the award, even no compensation was paid, no 80% payment was paid. It is some judgment says that Honorable Supreme Court judgment says that unless 80% is a mandatory one and it is not given, then, my lord, the position is to be treated as a void one. That lapsing goes.
That is the
But,
last
my lord,
question.
that has been finally settled by the Constitutional Bench. Finally settled. That judgment followed the
Indo development.
Yes, Indo development that has adopted the, my lord, the Satyanath Prasad Jain.
If
Well,
position.
it is clear. Even position 17(1), I am talking about not here. 17(1), if it is invoked, if the position is deemed to be a valid one, it is vested, even if no compensation at regard to 80% suppose was not paid, then position vesting will not go. That is clear. Followed the Constitutional Bench followed the judgment of Satyendra Prasad Jain. Now, after that, my lord, kindly consider, I have read the judgment of the Honorable Division Bench presided by the Honorable Justice Dipanga Atto. What is going on before this Honorable Supreme Court? One judgment says it is totally nullifying that other judgment.
Go and argue that before the Supreme Court.
Yes, no, my lord. My lord, it is happening. It is happening, my lord. My lord, so far my knowledge.
Whatever goes on there.
So far I have got some native knowledge, my lord, because I have come from the, my lord, the civil side. So I know how to
I also come from the civil side.
Yes,
So
I know how to
little
interpret. So, my lord, basic things, my lord, if I go through, if my lord, I go through the pioneer judgment, and my lord,
pioneer judgment is the judgments in your favor.
No, my lord. Not in my favor, against us.
That is the test of a good judge.
Yes.
Passes orders
That
in my
is
favor.
judgment, my lord. My lord, now, my lord, now we cannot follow what judgment will rely upon, what judgment will not rely upon.
Whatever is available.
Now taking back that, yes. First of all, the position, my answer to the first point, in every cases, if the position is that position by invoking section 17(1) or any urgency provisions in other statute, if it is a vested one, then position, suppose government didn't pass any award, say 100 years, that position still remain, vesting still remain. Government has become the owner of the land. It is the acquisition. Once the land, my lord has repeatedly made observation on the last occasion to my senior friend that acquisition and may acquire. What is the difference? Shall acquire. Now, my lord,
understand.
Yes.
If once it's vests by possession,
yes,
then that vesting is finally, that cannot be reopened. Only award
yes.
calculation of award.
Yeah.
Two questions on this. Against this.
Yes.
One is that even after this taking of possession in this case, 80% we are. So you have subsequently again withdrawn and issued new declarations. How do you answer that?
My lord, may I?
You yourself has opened it.
My lord, may I? Though I should not say.
You yourself have opened
but
it.
the officers, most of the officers.
We cannot say that officers will be inefficient.
No. If
but
it is,
you have, the state has reopened.
Whatever is there is there. My lord, kindly consider.
Whatever is there, we have to pass our judgment on whatever is there.
That's why I am making submission. My lord, kindly consider.
Legal
if the law.
What is the legal effect?
Legal context. Legal. I am coming to that. My lord, before that, my lord, whether Here position, just my learned senior friend has made a submission that unless the land classification be made in terms of the rules, so possession is to be treated as a void one, or is it in treatment not void one illegal? So he is relied upon the rules.
We have gone beyond that, Mr. Sengupta. We are not accepting that proposition.
Oh,
if under section 17, we are asking you a question. It's a fresh question, but on the same point.
Yes.
You yourself, you have subsequently issued declarations for the self-same property which you say had been vested. You issue declarations. You freshly propose to acquire them for public purpose, and you withdraw and again reissue declaration. So by this process, aren't you yourself accusing that vesting was bad? Because for a vested property, you cannot have a fresh declaration. What is the effect of the fresh declaration? You yourself reopen it.
May I give an answer to you?
Yes.
My lord, recently my lord has delivered a judgment while my lord is sitting in courtroom number division bench, presiding judge before courtroom number 10. Alarm that I didn't appear, but I have.
To the point,
yes,
Mr.
because if there is a statute, there is a prohibition in the statute, and the judgment that the learned lower court has passed an order, though he has got no jurisdiction, he is barred. So what will be the effect?
State can't waive.
Yes. What will be the effect? Effect, even if it says didn't prefer an appeal, does it mean that it is binding upon the state? No. My answer is, my lord has delivered a judgment.
No, forget my judgment.
Yes.
You have yourself, the state had itself declared,
yes,
published a fresh notification regarding a property, thereby admitting that it has not been acquired or vested.
No, my lord, subject to my lord's kindness. First of all, neither in the statute, neither in the Land Acquisition Act, Land Development Act, State Acquisition Act, there was in the time of section 6, section 4, section 6 and position. I need not describe the land classification, which he is already emphasized.
That's a different point. We are not asking you there.
No,
we are saying that for the self-same property, which you say has already been possessed, possession taken in 1951 or 52.
Yes.
Possession taken 50. Therefore, vesting was complete. Therefore, that vested in the state, and that cannot be reopened. Now, only what remains is award calculation.
Yes.
But after that, regarding the self-same plots, Mr. Sengupta,
not some of
the self-same. We are only focusing on the common plots. There is an overlap.
Yes.
For those plots, although you say that those were already vested, you again issue fresh declaration 4/6 again, withdrawn again 4/6 second time. So thereby you admit that those were not acquired, not vested.
Again, at the cost of repetition, my lord, if the law says it is vested, suppose I being the authority, I issued a notice withdrawing that other land. Does it mean that the vesting goes? I just put that question to
you say that is what we asked you at the first place.
Yes.
Even the state cannot waive the statutory provisions.
State cannot waive because doctrine of waiver is based on public policy.
Very well.
But private, my lord knows that judgment waiver, nobody can waive his
acquisition of land is also public policy.
My lord, I'm coming to
that's an exception to 300 capital A.
Yes, my lord, I am coming to that. 300A capital A is, my lord, kindly come. It is a constitutional right. It is a human right. I know that.
300A, the exception carved out in 300A, one of the exceptions is land acquisition.
Yes.
Because under reasonable, that state can make law to curtail that right of property.
Yes.
Now,
Now, my lord, kindly consider
it has been taken away from the fundamental rights section and placed in 300A.
Yes. Fundamental right cannot
be. So you can do that. That's why you are saying acquisition is also a public policy.
Yes. I am saying for that point. Nobody can waive his fundamental right. But the private person in whose favor the statute gives some power or some remedy, the private person, individual person can waive their statutory right, not fundamental right. But state under no circumstances can waive the fund.
When individual cannot waive a statutory, not a right. The operation of statute cannot be waived. You argue on operation of statute, by operation of law, it automatically vests.
It automatically vests, and state has got no authority to waive that.
Achha. Second question is that this vesting was not under section 17(4) or 9 or any of the provisions of this possession. Not the urgency provision under section 17, but section 8A of the 1948 Act.
And
right?
section 7, urgency
7, 8 under 48 Act.
48 Act.
Under 48 Act, as Mr. Bera pointed out, that it's only Bill, Bower and all those water bodies which can be taken possession of on urgent basis.
Yes.
So there is nothing on record to show.
No, my lord, so sorry to my lord, to my senior friend, my lord, kindly consider, he has relied upon a rules.
No.
It is required. It is required. Why I am saying submitting? When subject to my lord, sir, I will just kindly give me such 5 minutes time. I will complete. My lord, kindly rule 5. My lord, he just made a submission. His submission is based on that the classification of law is written here. That rules.
Our question is not based on that. His submission might be based on that. Our question is based on section 8 of the Act. Please come to section.
Yes, section 8, my lord, kindly before that, my lord, kindly section, my lord, what I am on.
Cannot override the section.
My lord, kindly what I am on, my lord, for the timing, my lord, sorry to say, my lord, kindly, my lord, don't make me under. My lord, kindly only thing, rule 5 is only to the extent of initiation of development scheme. And this is the notified area under public purpose. My lord, this notified area and the my lord development scheme is why, my lord, section 7, kindly see. Section 7 in case of urgency. Now going to the Act.
Have you asked you about applicability of Rule 5?
Then, my lord,
we are not even asking you any question on Rule 5.
Then, my lord, kindly see section 7. This is very important. Why vesting? My lord is saying that why vesting is the automatic, my lord. Kindly see section 6, 7 read with section 8. These are the sections are to be read as a whole. My lord, 7, my lord, 6 has already, my lord.
The urgency provision.
Yes.
Under 8A.
No. 7 first.
Otherwise, LA Act will be followed.
Yes, no, my lord. LA Act certain portion. Why I am submitting, my lord, is very 7. Kindly come to my lord has read section 6, section 7. In case of urgency, if in respect of any notified area, my lord, kindly see, the provincial government is satisfied that the preparation of a development scheme, it is, my lord, kindly see, is like.
Sengupta, we are operating parallelly. These operate parallelly. Section 7 only waives this development scheme under Section 5. Section 7 of the 1948 Act, Development Planning Act, only waives, obviates the necessity of Section 5 scheme.
Yes.
In case of urgency.
In case
that
of urgency, yes.
That footing also.
Yes, that is, yeah, even if it is not a planned, yes, development scheme is not there, then it's also.
It stops there.
Now, section 8.
Then 8 has to be followed.
Yes, 8. Yes, I am coming that.
8 after making a, please read
kindly see, a declaration under section 6 shall be conclusive evidence that the land in respect of the declaration is needed for public purpose.
This is?
Now, A. My lord, this is, my lord, previously was done.
1, please read first, after making a declaration.
A declaration, my lord, I am 8. My lord, kindly see, after that 1955, it was amended. 91, now 1A has been inserted. My lord, I have made submission on that respect.
You rely on the previous provision?
Previous provision, because I want to make submission on the basis of the first, this is 1940, that is there, section 4 was not there. Section 4A was not there. After that, by way of amendment, 1955, these certain portions have been amended. Well, I have handed over that the amended Act.
Just find out the unamended Act.
Unamended Act. Well, this is unamended Act.
But the copy given to us is amended, so let us find out that also.
Well,
you must have.
I have handed over. Yes, well,
just find it out. Give us half a minute. Unamended declaration.
Why I have, my lord, placed this, my lord, first Act, then, my lord, amended provisions. Because their section 4 was not. My lord, I am handing over my copy, my lord.
No, need not. Yes.
Yes. My lord, this is, my lord,
a declaration. Please
yes,
read it.
this is first, my lord, 7th October 1948. My lord, first portion of the.
A declaration?
Yes. My lord, kindly see section 4. My lord, kindly see, I am.
Don't start from 4, 8.
Oh, 8. Yes. A declaration under section 6 shall be conclusive evidence that the land in respect of which the declaration is made is needed for public purpose. After making such declaration, provincial government, now it is state, may acquire the land. My lord, kindly see there, my lord, joint issue, my lord, repeatedly asks my senior friend, may acquire, that should be shall acquire. Acquire the land, and thereupon the provisions of the Land Acquisition 1894 so far as may be applied. This is very important. So far as may be applied. To what extent Land Acquisition Act 1 would be applicable? Whether 11A will be applicable? No. That is the judgment I have cited, my lord. Kindly see, so far as they may apply. And my lord, kindly see here only section 23, that is B, kindly see. Only section 23 of the regarding assessment of compensation, and my lord, nothing else. After that, my lord, the amendment which was carried out in the year 1955, kindly see that. Now, vis-a-vis, kindly, my lord, kindly see that section 8, there is a 1A is added. There, my lord, kindly see, there also 11, only 11 for assessing the award.
But 8 proviso A remains the same.
Yes, self-document, but 6.1A, it is because 6.1A, kindly see the, and my lord, compare with that, my lord, the amended provision. 6.1A has been inserted in the year 1955. Same.
But this post-amendment would be more beneficial for you.
Yes.
Pre-amendment, if pre-amendment is applicable, it goes in his favor more. Why we are saying, we are explaining. In post-amendment, Mr. Sengupta, the language has been used. After making a declaration under section 6, the state government may acquire the land, and thereupon the provisions of Land Acquisition Act shall apply. Oh, so that remains the same here.
Same. My lord, I have gone through, my lord, I have read in between lines.
No,
because so far as
read the lines first. Read the lines first, then we'll go between the lines.
Out of anxiety, because he has taken so many
we have
time.
been so long roaming around between the lines. But let us come to the lines also.
Sorry. So far as everything is same, my lord, kindly consider, my lord, if the land
is, tell us this. Under the proviso, Mr. Bera has taken a point that yes, may acquire the land, and thereupon the provisions of Railway Act shall apply.
Yes.
Provided that if in any case, provincial government so directs, the collector may at any time after a declaration is made under section 6 take possession in accordance with the rules of any bill, bow, tank or other watery area or any other waste or arable land in respect of which the declaration is made, and thereupon such land shall vest absolutely in the crown. So therefore, it has to be a bill, bower, tank or other watery area. Do the records of rights support this contention of yours that it is a bill, bower or a water body? There are land, other.
Yes, may I put in another way? My lord, I am putting it another way, subject to my lord's approval. My lord, kindly see now section 2. Section 2 of this act, kindly see. Land means what? May I kindly see?
What? Tell us.
Land
definition. Same meaning as Land Acquisition Act.
Land Acquisition Act.
Same meaning as Land Acquisition Act.
Same meaning as Land Acquisition Act. Land includes everything.
Yes, but the urgency provision cannot be invoked unless it's a water body.
Well, that cannot, well, kindly see, this has to be read. Well, kindly see. Well, taking possession, there was, well, kindly see, neither in section 4, neither in section 6, neither in certificate of possession. There was no law exists for give or the duty cast upon the authority to give the land classification of land which has to be there in section 4 and section 6 and section 7A, 17 or physical possession certificate. Nothing is there.
Scheme of the Act is very clear, Mr.
Yes.
Sengupta. After making a declaration under section 6, state
Yes.
government may acquire the land and thereupon. That means you acquire the land and thereupon the provisions of the LA Act shall so far as may be apply.
So far as they
Proviso says,
yes.
if in any case state government should direct, the collector may at any time after a declaration take possession in accordance to such and such.
Bill,
then
according
it shall
to
be-
of any bill, board, tank and other
water
water,
bodies
any
and-
other waste, arable land. My lord, may I submit, my lord?
No, you may not, because you have not finished yet.
Yes. Which will declaration is made? For which declaration is made?
One sentence.
Sorry.
So it says, after making a declaration under section 6, the state government may acquire the land and thereupon provisions of LA Act shall apply, as far as may be. Proviso adds, if in any case state government so directs, collector may at any time after a declaration is made under section 6, take possession in accordance with the rules, any bill or such and such, in respect of which the declaration is made, and thereupon such land shall vest absolutely in the government.
Yes.
If this is not invoked, then Mr. Sengupta, only by 8(1), land does not vest.
My lord,
Acquisition operates under LA Act. In your case, you have to satisfy that possession was taken under this provision.
position, my
For
lord,
it to be taken, bill or tank or water
my
area
lord,
has to be the
my
classification.
lord, the position at the time of taking the position, no description as no description or land classification.
Records of rights are still available today. Those are not part of
My
the
lord,
record.
I, because he missed it, but I found it. That's why, my lord, I have come up with the application for taking additional evidence. My lord, it is ready. My lord, kindly come.
Under the
that-
table transaction.
Yes, that everything is there. No structure is there. I have gone through, my lord. ওই এটা কোথায় গেল রে?
Structure, who speaks about structure? Whether it's a watery body or
Watery body, agriculture, watery body, everything, pond, everything is
no
there.
land there. You're going down and down.
My lord,
How far
এটা-
do you stoop for a matter?
No, my lord, kindly consider. Because I have come out with the application, my lord, just now, my lord, I have to pay leave when affidavit has been
You have not
completed.
yet filed the application. Forget it. Just forget it.
My lord, here,
Hearing is almost concluded.
Yes,
Now you're on
yeah.
rejoinder.
here, my lord, at the time of, my lord, only these things will come up at the time when, my lord, inspection is to be done, physical position inspection.
We directed you
and
to produce the records. If this is not a part of the records, why should you take?
Yes, but my lord, he has inspected that documents. He missed it, but I have located.
It's a part of the record.
Yes, it's part of
What
the
is
records.
there?
My lord, kindly see.
No, what is there? Just tell us.
There are the lands, my lord, here, my lord, 8.73 acres.
No, we are not on that. Whether it's bill, bow, tank.
Yes. Bill bound tank, others are there. My lord, kindly see, arable, that is other any other waste arable land, that is like agricultural land.
Waste or
Waste and arable. In respect of arable means, my lord, some kind of agricultural activity. My lord, kindly see Danga Shali. Shali means agriculture. My lord, tank.
So you see, it satisfied this category, and
Yes.
therefore 80% payment shows that possession was taken.
Yes.
Certificate of possession is also.
My lord, Shali, tank, Pukur, Danga, Shali.
Got it. Got it.
Well, that's why I have come up with this, so that my lord can, so that they may not take any. They got the opportunity to make inspection, but he missed it. But I found out that this point
You have found out that that's
because
credit
may,
should go to you.
yes. My lord, kindly consider one thing, my lord, my lord,
What-
this is, my lord, what I have made submissions, my lord. First of all, that suppose only section 4(6) position, suppose, assuming but not admitting. possession was, my lord, according to my lord, if
Declaration made.
possession, that declaration, that is a void one, or that is not vested. Then whether 2013 Act is applicable. That is the fundamental question.
It's a different question. We are not very satisfied with Mr. Bera's answer to that.
Yes, madam, kindly see.
But we will consider. We have not closed our minds.
Yes, madam, kindly see. But I have relied upon, madam, 3 judgments. One, that is 2020 Indore Development 8 HCC.
You also have your stock judgments.
Yes, only 3 judgments. I have not,
Write those in all matters.
2000. No. 2000.
The development.
Indore Development is
required. Matrimonial matters, if those come, you will cite Indore Development.
Indore Development is required because
the spelling of Indore will change.
The ratio is, my lord, because it is helpful. So for the land, the acquisition is concerned.
Ajiman Baby, Bangalore Development.
No, Ajiman Baby, no. 2028 SCC. And my lord, I have referred, my lord, this is 2022 14 SCC.
That is Bangalore Development Authority.
That is Bangalore Development Authority. That is the mainstay. My lord, kindly consider this. This is, my lord, legislation by incorporation. What is the difference between legislation by incorporation and legislation by reference? This is legislation by incorporation. So, my lord, my submission, my lord, kindly, I am just, my lord.
So you say that the Land Acquisition Act has been incorporated in the 1948 Act.
Yes, but kindly see.
You are arguing against yourself.
No.
If the act has been incorporated, then the acquisition is under
up to what action, my lord, that is the kindly see. My lord, land.
It's by reference because it refers to some of the provisions.
My lord, kindly consider one thing. This is legislation by incorporation. Why I am making some, not legislation by reference. Supreme Court held that is under the BDA Act.
Yes.
Because first point, Supreme Court negated, the revision bench allowed that. The Supreme Court set aside that order. First initiation was made under the BD Act, Bangalore Development Act.
Yes.
So, under no circumstances, if it is initiated, then 2013 Act is not applicable. First. Second submission was made that this is a legislation by incorporation. Even the 1894 Act.
1948 Act was never repealed.
No, it is still in existence.
Therefore, this logic of his does not apply.
Yes. Madam, kindly consider 1894, even if it is repealed, but the provisions
1948 has been repealed.
No, 1894. That is Act 1.
That's a
even if, yes, that's why I am saying, I am reading one paragraph, madam. Incorporation of an earlier act into a later act. Earlier act, what is, I just put that question to myself. Earlier act, that is 1948.
Yes.
1894, that is the Act 1. 1894. And latter act, that is 1948.
Yes.
So incorporation earlier act.
That's the same, only the positioning is
yes.
Is different. 1948 and 1894.
Yes. 1894 is an earlier act. If incorporation of an earlier act into a later act is a legislative device for the sake of convenience in order to avoid verbatim reproduction of the provisions of the earlier act into the later act. Once the incorporation is made, provisions incorporated statute become integral part of the statute in which it is transferred. Thereafter, there is no need to refer the statute from which incorporation is made. Any subsequent amendment made in it has no effect on the incorporated statute. Now, I am putting that question to myself. Now, and my lord, there is another provision that even that act repealed, the state may proceed with that act, BD Act, here, my lord, the LDP Act. My lord, why I am submitting, my lord? Why? Because here, and 11A is not applicable because it is not written in the statute book, that is the BD Act. Here the same. 11 Act, by dint of amendment, it was introduced. So if any amendment, if it is not incorporated, then amendment has got no force or is not applicable herein. Herein, so my case, it is not applicable. So my lord, kindly consider one thing, amendment, any subsequent amendment made in it has no effect in the incorporating statute. So my lord, now 11A is not applicable. Because, my lord, here the Honorable Apex Court, my lord, has relied upon one provision that is incorporated in the BD Act. On the basis of that, this judgment has come out. My lord, provision section 36, which paragraph 11, I have already cited, of that judgment.
Yes.
Chapter 4 of the BD Act deals with acquisition of law. This chapter comes with under contains section 35, factor 6. Relevant portion of the provision for the purpose of 36 is as under. Acquisition of land under the acts otherwise than an agreement by within or without Bangalore area shall be regulated by the provision so far as they may apply land acquisition act. Similar. So, madam, my respectful submission would be, and my lord, kindly see that here they took a point that 11 is applicable. No, the Honorable Division will no, it is not applicable because it is a subsequent amendment and it has. Yes.
Para 20 makes it very
Yes,
clear.
madam, kindly come to page 16, paragraph 16 of that judgment, paragraph 16, clause 15, that is regarding 11A of 24(2) of the new act.
Yes.
Now, where a subsequent act incorporate provisions of a previous act, then the borrowed provisions become an integral and independent part of the subsequent act and are totally unaffected by any repeal or amendment in the previous act.
Of course.
Then, so even if it is repealed, 1894 now it has been repealed. So I can go by, I can follow the provisions incorporated in the LA Act itself, only regarding passing an award and regarding assessment under section 23.
Because 1940 Act still remains.
Yes, still remains. My lord, now, my lord, kindly consider I have taken it because waiver, state has got no role to waive there because it is based on public policy. So even if, my lord, this state, my lord, I have found so many things, my lord, which I cannot, right now, I cannot make any submission on that behalf. But my lord is utter, because that is totally, they have misconstrued the law. They do not know even the law.
Who?
I should say. Officers. They are the big officers.
State officers.
Yes, I have gone through, my lord. Even I have taken, my lord, this is, my lord, because I am facing a brilliant judge, according to my opinion.
Us,
so
we are brilliant.
Brilliant judge.
Oh, thank you.
My lord,
you win.
This is not.
No further.
I have no. I have no. I have no. Because I am not the person to praise my lord. I am not the person.
That one statement means you.
No. Something.
Nothing else is referred.
My lord, now, my lord, kindly I have referred our Honorable Division Bench judgment, which is reported, my lord, has pointed out, that if it is
only thing I hurriedly
now you cannot say anything about us.
I have what I have subsequent I will not argue. Hurriedly I could not dare to decision.
এখন আবার decision এর জন্য
That's what I have held.
No. My lord, you have got enough opportunity.
Whatever Mr. Sengupta says is law in this court.
No.
He says you are not
that is, my lord, my lord, another judgment I have relied upon. My lord, another judgment I have relied upon. My lord, kindly consider.
Suddenly, I forgot to deal with the case.
আরে স্যার কতক্ষণ নেবেন একটা মামলা নিয়ে তাহলে তো আমার সব মামলা চলবে
Yes, Mr. Sengupta, you are also.
Yes, my lord, only one thing, my lord, that judgment, my lord, I have also relied upon, that is I have handed over, that is Honorable Division Bench of our High Court. It has been reported, but my lord, I don't, my lord, that is MAT 86 of 2016, State of West Bengal and others versus Niladdi Chatterjee and others. Here it is categorically stated, my lord, in the last, that is paragraph 34. My lord, I am just reading 34 or something.
Yes. You said you are not relying on.
No, I have relied upon.
And
he has taken note of it, my learned senior.
I have not argued.
So I have not argued, this is your fault.
Yes, that's my.
Madam, kindly see, madam, that judgment, that is the last portion is category. Yes.
Yes.
Undoubtedly it is yes. Well, I got it. Undoubtedly it is only the duty of the collector's failure to issue notice under section 3B of the Act of 1894, land acquisition stood lapse. However, whether ipso facto such a lapse translates into claim for compensation under the provision of Act 2013 can be answered simply by visiting provision section 24 of Act of 2013. It will be noticed that from plain reading of this said section, there is a phrase, proceedings initiated under the land acquisition. In the facts of this instant case, my case is better than that because it is section 41A. Touching section 41A Act 2, that was repealed. That is that was a temporary act, and after 31st March 1997, the stands repealed. Proceeding initiated under land, in fact, in the inside, it cannot be held by any state of that proceedings were ever initiated under the said Act of 1894. And as such, abdication of statutory duty on the part of the collectors to issue notice under section either due to sheer carelessness or negligence on his or part cannot ipso facto translate into a claim for compensation under the Act of 2013. It's clear because after all, it's a division bench judgment. So after reading down the section 24 of the Act 2013, and my lord, at that point of time, my lord, this Supreme Court judgment that beat Bangalore Development and the Indore Development has come on, has not, these judgments were not being delivered. But before that, my lord, the Honorable Division Bench come to a finding that yes, if it is initiated, because I pointed out when I was there, my lord, I am not glorifying myself, my lord, but I am part of.
Out of what?
Well, I was there as an appellant. Well,
when? Before the Supreme Court?
No, before the division bench.
This matter?
Yes, in this
yes,
matter.
you were there.
Yes. That's why, my lord, I specifically submitted that this initiation, if it is being made, if initiation is being made under Act 1, then 2013 is applicable. But if it is not initiated, because no, it is in section, in respect of section 41A of the Act 2 that now repealed. But here my case is better than that. Because still survives and doctrine of incorporation, that is legislation by incorporation, squarely applicable. That is my exclusive submission.
You want to file a written notes or arguments, or we'll close arguments here? So, whatever you say.
Well,
I think my 18 notes of argument, kindly.
Cases cited by him, I forgotten to
Forgotten.
make any comment, but
Already we are in rejoined, we have here.
I will make a note of it. He has relied upon some judgments.
What is your line of distinction on those judgments? Tell us, because you cannot incorporate in a written note something which you have not argued.
Oh, well, only thing, mirror the your lordship today is not hearing whether it is a legislation by reference or legislation by incorporation. There are host of decisions on this point, divergent views are there. That is not the subject matter of this case. It's restricted to that part of the acquisition only under the land acquisition. Whether it is by legislation by reference or incorporation, your lordship is not referring. I have got judgment, I have not. Host of judgments are there, but I have relied upon that may be right or wrong. After all, Ajiman Bibi's judgment is there where it is 11A. Unless that is set aside, there is no scope to reopen. Your lordships can distinguish this. I am not saying every judgment is per inquiry, certain things are not. But so far as this 2214 SCC is concerned, that is on BDA Act, it has been held there. It is a self-contained code. So far as this concept of law is concerned, legislation by reference, legislation by incorporation, and a complete code. Wherein in Girnar case, it has been completely held by the Supreme Court that this is a different concept. If a code is complete code, then it is not necessary whether it is legislation by reference or legislation. Complete code means everything is there. So, my lord, it is not a complete code according to me. So, I am not I will rely upon this. It is only one judgment. One judgment you cannot decide this issue. Since there is one, at least Supreme Court judgment is there, Ajiman Bibi is there. Then Niladdi Charaj is a case under Act 2 that I am not relying upon. So far as waiver, the Indore Development Authority is concerned, he has relied upon 353. I only relied upon 362. It clearly says each case is to be independently decided, particularly in cases where awarded money has not been paid.
Para?
Para 362. Your lordships can read that. That is your lordship. Indore Development, sorry. Para 362. Indore Development is completely restricted to 24Q. You cannot come at any time after the declaration of award that your proceeding has should lapse under 24Q. Here, not a case under lapsing under 24Q. So, if other cases are there where award has not been, that is to be decided by your lordship separately. So, Milord, in my note, I will refer to this. I will deal with this.
Hearing oral arguments are concluded. First up, learned counsel shall file their brief written notes of arguments on Monday.
Kindly.
When?
Next Thursday, I will in the morning.
On
Kindly take it on.
December 11, 2025, when the matter shall be listed under the heading to be mentioned for such purpose.
Yes. Milord,
Very brief written notes, Mr. Shen. Only bullet points. Judgment copies you need not give, either of you, because you have already given. Only bullet point, half page, 2 page.
2 pages it will not do.
Well, I think
No, no,
1
2
page
page.
is sufficient. So far, I am concerned.
But 2 page only. Refer to the pages and proposition of law and refer to the judgment. Not a re-pleading.
Very well, Milord, then I will not defer what I am. I will try to admit it may be 3-4 pages.
That's a very good.
So far as writing is concerned, written notes, I cannot
Very.
do not go to write places. Nowadays I have forgotten. But in our school days, Milord, we have to write places.
Thank you.
How much time you lost?
No, not our time. Your litigants' time. Our time is your time.
So far as my eye must be can be very lost. I do not want to misguide any.
Misguide? Who told you have misguide? You never misguide.
My only endeavor is to.
You have never misguided. We don't think we have misguided us ever. Yes. Call on the next one. Doctor. Yes, Mr. Bhatt.
For the response.
Right.
I was addressing your lordship, Lord, in reply to the submission made by Mr. Bandyopadhyay.
Yes.
To summarize, Lord, what I have submitted on the last day, Lord, firstly, lease is of 2019, although LOI is of 2013. So I submitted that after the LOI, 16 rules came into force and lease was subsequent. So he will not get benefit of 62.2. This was the first submission I made. But although LOI is saved by section rule 61 proviso, which says that if LOI is issued, lease shall be subsequently executed. But 62.2 is not applied to this case because of the fact that lease is a subsequent event. No action was taken by executing the lease. So lease is not saved. This was the first submission made. The next submission was, my lord, that their submission was that we have a vested right or accrued right of renewal. On that I submitted, my lord, that firstly the renewal clause although starts with the wording that at the option of the lessee, but the entire clause has to be seen.
Only vested right is to make an application, not to get a renewed.
Consider that part is the only right of consideration if it is saved.
Yes.
So, and the judgment that they relied upon on interpretation of the terms of a renewal clause, the same judgment has said that the language is to be looked into. There cannot be absolute right of renewal as per the language. If the language says that if option is exercised, it shall be renewed without any reference to the lessor. In such cases, it might be a vested right of renewal upon exercise of option, but this is not such a case.
All right.
Next, Lord, they said that Rule 36 should protect them. of the 2016 rules, which says that the rights of a lease deed are protected. On that, our submission was that the language of Rule 36 clearly says a lease under these rules. A lease which is executed in 2002 rules shall not be covered by Rule 36.
Yes.
I've shown the definition of lease under these rules.
Right.
So they will not get benefit of Rule 36. Then the next submission was that Rule 3, Clause 3 in the lease deed, it is not an exact replica of Rule 12. Some of the conditions laid down in Rule 12 have been imbibed in the Rule 3.
Yes.
But it is not an exact replica to for them to argue that the entire rule has been imported in the clause. I have shown the clause and the rules, some clauses are there, some clauses are not there. So, Rule 12, if Rule 12 is not there, and they don't have any right flowing from 62.2.
They have a right of refusal without reason also.
The right of refusal is there. We can refuse without reasons also. So, Rule 12 is not imported, so only Clause 3. They can rely upon the contractual Clause 3. Then, Section 56 of the Contract Act comes into force.
Yes.
Now, 56, there are two parts. One is, at the time of entering into the contract, it is impossible. And the second part is, if during performance of the contract, it becomes subsequently impossible of performance. I say it is a case where 16 the new rule came and 19 the lease was executed. So the first part will apply. Parties knowingly have entered into a clause which was impossible of performance because under the rules it was not possible to renew under Rule 12.
No, the second part will apply.
The second part is when during continuance of the lease it becomes impossible. In this case, the lease is subsequent. The same reason why Section 62.2 will not apply.
So please repeat that once again. You argued on the last version.
Section 56, first part is,
yes,
if at the time of entering into the contract, the performance of a particular clause is impossible at the inception of the contract. The second part is, during performance of the contract, some clause becomes impossible of performance.
So here you say the first one applies.
First one will apply.
At the time of entering,
it was impossible. So this clause was not possible of being performed because Rule 12 was already gone.
LOI saved the original contract.
LOI saved the contract, lease was executed, but the lease was an action contemplated, not an action taken.
That you have taken.
So Section 56 will apply to this case in my humble submission.
And Section 6 General Clauses Act, you also said something right of consideration only, not right of renewal or something. Just touched by you.
I'm just not Section 6 of the
anything not in force.
6A, they say they have relied on C, 6C, which says
Effect of repeal.
Affect any right, privilege, obligation, or liability acquired, accrued, or incurred under any enactment, so repeal.
There you probably submitted that right of consideration only, not right of renewal.
Consideration under the.
This is an extension of your previous argument that
A is 6A. Unless a defined intention appears, the repeal shall not revive anything not in force or existing at the time at which the repeal takes place. In this case, at the time of execution of the contract, it was already repealed. In 2019, the lease was executed, and by that time, the rule of 2002 was gone. So, A shall apply. It shall not revive anything not in force or existing at the time at which repeal takes place. 6A. 6A will apply.
No, but it was in force when the repeal took place.
Lease
2002 was there.
Lease deed was not in existence. 2002 rule was there.
This says the repeal, where this act or any central act or regulation made after such and such commencement of the act repeals any enactment hitherto made or hereafter to be made, then unless a different intention appears, the repeal to that act shall not revive anything not in force or existing at the time at which the repeal takes place. That means that if it has previously lapsed or previously was not there when the repeal took place, then it would not revive. Even if it is stated in the new act that these portions are saved. Saving clause won't apply to something which was not there at the time when it is. This is not applicable to you.
C, they have relied on C.
They have
relied that the repeal shall not affect any right, privilege, obligation, or liability acquired, accrued, or incurred under any enactment, so repealed.
So you say that under the previous enactment, only the right to apply for renewal.
So on the date of repeal, my lord, there was no right at all, no right for consideration, because the lease deed was not executed. Repeal took place in 16, lease in 2019. So on the date of repeal, no right, there was no right, accrued right or not privilege.
Through the LOI.
So if
No.
read with A,
previously it was there under the 2002 Act.
2002 rules, it was there, my lord. But during subsistence of the 2002 rules, there was no lease deed, only LOI. Only letter of intent was issued. 2013 letter of intent.
No, as per this, when the new act, the new rules came, the 2016 rules came, at that point of time, 2002, that right was available to them. This says affect any right, privilege, obligation acquired, accrued, incurred under any enactment, so repealed.
Yes. So it shall be acquired only if not the lease is entered into.
Right, privilege, obligation, or liability acquired.
Acquired. So on the date of execution of the lease deed, he will acquire the rights and liabilities which are contemplated in the lease deed.
So because there was no lease deed, the right had accrued.
So no right has accrued. And A says it shall not revive anything not in force or existing at that point of time.
A is on a different.
C, he will not get benefit of C because of the date of the lease deed. Now, my lord, two judgments were relied upon by my learned senior friend, my lord, on a similar matter, my lord, on which your lordships held.
Yes.
That in view of incorporation of the language of Rule 12.
Yes.
My lord, by spirit, the rule is imbibed in the rule. They will get benefit of the rule. On that note, the first distinguishing feature is, my lord, that in both the cases, my lord, the lease was executed prior to repeal of the 2002 rules, prior to 16. So they had the benefit of 62.2, Rule 62.2, which saves the rights. Those were available in those cases.
That is the distinguishing fact.
That is the main distinguishing fact. But in this case, my lord, lease was not executed. 62.
What about any challenge has been preferred against this? Do you have any idea? Because you are the state, you should know.
No.
You should have taken instruction in the meantime from your office.
No, so far as I had a talk with Mr. Chaturvedi, but he is not aware of any appeal. But by course of today, but I'll once more.
I told you, we asked you on the last occasion also. If it is pending, then it does not affect. But lease deed was already executed in those cases.
In those cases, lease deed was executed, so Rule 62.2 benefit was available to the lessee, which saved certain rights. But in this case, that right is not there.
Right.
So those judgments are distinguished. Secondly, my lord, your lordship, on the facts of that case, my lord, after going through the clause of the renewal clause, observe that entire Rule 12 has been imbibed in the clause. But in this case, I have shown to your lordship that certain portion is left aside. So this much is submitted on the last day. Only, my lord, 2 points I will add, my lord, today. First is, my lord, if your lordship takes up the application made by him, even the averment, he is not saying that he is making the application under clause 3. The application was made in the pleading of the deed as well as in the application form. It is under the rule. If your lordship kindly takes up page 200. No, page 200. 200 is the application 200 as
এটাতেও আছে এই তো অ্যাপ্লিকেশন দেখো 198 30 10
Lordship will kindly come to page 198. P13 198 of the application. Address to the ADM. Application for grant of renewal. Typed page 199 is the typed copy, my lord. Kindly come to page 199. Kindly see, my lord. Subject is application for grant of renewal of our aforesaid mining lease under the West Bengal Minor Mineral Rules 2002. With reference to the above caption subject, we are hereby submitting the application in Form D for grant of renewal of the aforesaid mining lease along with the necessary documents which may kindly be acknowledged and received. Next page is the application in Form D, page 200. It is under Rule 12.1 of the Minor Mineral Rule 2002. So the application was made under Rule 12 and the averments in the writ petition, if your lordship sees in paragraph 17 and 32. Here also, it's an admitted case.
Paragraph 17.
17 at page 9 and 32.
Averments also that under rules.
That the application has been made and they have a right under the rules for renewal. That is the case made out in the petition. And no reference that under the contract we are claiming for the renewal. Now, once the rule goes, the rule is repealed. The authority under Rule 12, which is to consider the application, they also lose their jurisdiction to entertain an application under Rule 12. The authority becomes functus officio. The application made under Rule 12 by an authority which has lost its jurisdiction to entertain such an application, that is also not an impossibility to perform. Even if we fall back to clause 3, the authority is not empowered anymore to consider under Rule 12. So he has lost his force to consider. And the last point is, my lord, my junior has not pointed out the alternative argument, my lord. Rule 12.6 is, my lord, deemed renewal.
Rule 6 of the previous 2002.
2002 rules is deemed renewal.
Yes.
In this case, my lord, and Rule 12.1 says, and the lease deed also says that you can get only one renewal. Only one renewal. Now,
what that deemed renewal?
He has already got the deemed renewal.
The deemed renewal cannot be counted to be that one renewal. That is an absurd.
Kindly see 12.6 once, my lord. If an application for renewal of a mining lease submitted to the receiving authority within the time as referred to in sub-rule 1 is not disposed of before the date of expiry of the lease, period of that lease shall be deemed to have been extended for a further period of 6 months or period ending with the date of receipt of orders of the state government thereon, whichever is shorter. So,
bad argument. You know why? Because this is only a stopgap till then. And otherwise, this term would not be used that till then order is passed.
Till the order is passed.
Because the order is passed for renewal only.
We are putting emphasis on the whichever is shorter. So
no.
But
that is still whichever is shorter between what? Between 6 months and passing of the order of renewal.
The order of renewal, whichever is shorter. So if 6 months is shorter, renewal may be for 5 years.
But yes, but still the order has to come. The order has to come. That's the stopgap. Yes. Because it would not contemplate in further order. That order would be for renewal. And not only that, this 6 months then curtails the period otherwise given under Rule 12.
One cannot take advantage of
5 years. Another renewal for 5 years. That cannot be curtailed by us.
By our own inaction.
Yes.
Alternative argument. So these are my points, my lord. So we humbly submit that in view of the change circumstances, they cannot ask for renewal in this case at least, where 62 benefit is not available to them. And the clause also doesn't permit something which is impossible of performance.
Right. Thank you. Yes.
Kindly take first page 76. Once.
Yes.
Now this is, kindly see the subject. The grant of long-term mining lease for Blackstone to Sukriti Pebbles in Mouja Satansat, and note the date. It was 7th of March, 7th of March 2013, most probably. 7th of March 2013. On 7th of March 2013, actually the grant was made. And under the rules of 2002, there was only thing, applications and grant. Now what they said, Malad, kindly come down. Malad, I need to deposit a security deposit, Malad B, 500 deposit. Then I further required to deposit 2,500. Then D kindly take. Better copy.
Our copy is legible. The draft mining lease deed shall be in the modern form.
Next page, I don't think whether it is legible or not. 77.
No, almost not.
That's the problem.
No, next page is almost not legible.
I'm trying to get it. So, yeah, I'm just drawing the, kindly take D.
Why are you placing it? For what purpose? Tell
Yes.
us that.
Malad, under 2002 rules, malad, there is an application for mining lease and grant. The execution of lease was formal. Kindly take D.
So you say the grant was the lease
Grant was
for
the
all
lease.
practical purposes?
All practical purposes. It will not take
The
effect.
formal lease deed was a formality only.
No, the lease deed will come because without lease deed, I cannot function.
If you say that you cannot function, then his argument is correct that lease deed was subsequent.
The lease deed actually subsequent in 2019. I cannot alter the factual situations. D kindly take the draft mining lease shall be in model form, the statutory form. Industry is aware that 6(3) leases under West Bengal State Acquisition Act. These
But then
are all.
what is your point? That this is the lease deed is a formality only.
This is a lease deed because it requires, because lease says the lease rental, ground rent, and other these were there. So as soon as I was granted the mining lease under 2002 rules, when the 2002 rules was subsisting, so my right accrued for a one-time renewal. Even if ultimately lease deed was delayed, it was executed in 2019. Because the grant
lease deed has to be constituted to be a mere formality.
It has to be constituted to be a mere formality because it's preceded by the grant. Grant is the actual thing. Now, if I can give you lots of the comparison. Under the estate acquisition, the one is allowed to retain. So for the tea garden and factories land, there is first comes the retention order. And if you see the rule 4 of estate acquisition rules, that retention is subject to certain conditions. Now, one of such conditions is execution of the lease deed. Even if the lease deed was not executed, that retention remains. So this grant remained, and the grant was under the 2002 rules. As soon as this grant came into force in 2013, so my right accrued under the 2002 rules. Even on this, I'll show that there further argument, applicability of 61 and 62. I'll show. I'll come back on after.
We'll continue after this.
Yeah. Better, my lord. Now, kindly take, my lord, now. And I have shown the grant, my lord, and that was the right accrued. Now, kindly take new rules, 2016 rules.
Yes.
61 first, my lord.
Yes.
All applications for mining lease or lease of minor minerals, including the reclassified minor minerals such and such, received prior to the giving effect to this rule, irrespective of its duration or pendency, shall become ineligible. Provided that if the applicant has been issued a grant order or letter of intent or any other government order requiring alteration of the applicant's position, then his mining lease application may be considered after due compliance of all necessary conditions. My applications, considerations completed, but when the grant order came, I'll show from the 2012 rules itself. It says applications and grant. Formality is the execution of the lease deed. All right, if we go by this 61 proviso, then I would have been granted 20 years lease because 2016 rules provide for 20 years lease. 2012 rules provided from 5 years to 20 years. Here only 20 years lease was provided. And I'll come back to 2012 rules to show that there was only applications, then grant. And the execution of the lease is as per grant in Form D.
Now, how does the proviso apply according to you?
The proviso,
in your case?
There may be some letter of intent. This grant order, I do not.
Grant order or letter of intent.
Yes, but so far as the grant order is concerned, kindly take 2012 rules. Grant is grant of mining lease. And that was, I had shown page 76. This is
so you say this grant order covers your grant? This grant order covers your grant?
No, the grant order, this grant order didn't cover my grant because I was already granted. Only the formal lease was executed. There's no, because 2012 rule says, kindly just 2002 rules, Marat. Rule 5 says applications for mining lease. Then 6, acknowledgement of application. Then 7, disposal of the application for mining lease. My philosophy says 2002
yes.
rules, rule 5, application for mining lease. Every application, then clearance certificate, then kindly take 6, acknowledgement. Then 7, disposal. Right? Doesn't. Then 11 says period of lease. And 12, renewal of lease. So it doesn't, in my humble submission, I may be wrong, but so far as my reading is concerned, the grant is conclusively gives me right to get the lease in Form D. Because lease is in Form D.
Grant is under section Rule 7, it's a disposal of the application.
That is the grant.
That is the grant.
That is the grant.
That confers you a right. So after that, there is no scope of
no, there is no scope
deviating from that position.
No,
they have
deviating from that position.
So why did you place proviso to Rule 61 here?
Because they relied, what they said that 2019 lease was executed by invoking proviso to 61. So once it was executed, invoked, so I cannot have the renewal.
You say that is not applicable.
That is not applicable in the present case. Now 62.2
since grant had been already
there in 2013. The lease could have been executed in fact, it should have been executed within 1 month. Because the subsequent rule says it should be executed within 1 month.
Which rule says that?
I'm just
2002.
2002 rules. I don't also find it, my lord, I've seen somewhere. Then refusal 8 is refusal.
No. Within 30 days.
No, that is within 1 year. That was the date of Rule 7. That was the date.
That is different.
That is different. No, nothing has been mentioned that when the lease to be granted, nothing. The lease is under Form D.
Let us just check up.
Let us see the Form D.
No, first.
Form E.
No.
This is Form E. I'm sorry.
The 2002 rule, where is the provision for formal execution of a lease deed?
Rule 24(1).
This says the lease shall be drawn up.
Yes, only lease shall be done because the grant was the final thing.
Yes, let us see whether any.
And you'll also kindly tick for me that only refers to Rule 24(1).
That is there. Period of which the management is granted. So disposal per se means.
Per se means grant of mining lease. That's my argument.
In the rules, 2002 rules, there is no scope for any lease deed, formal lease deed.
That is 24 because the application is for grant of mining lease. Now the grant came.
Rule 15, my learned brother says.
I'm just checking it up.
Yes, absolutely. He's absolutely right.
Within 6 months. That is why I said so somewhere I had seen.
My learned brother pointed.
Kindly check 13. When required, state government and application for shall that 500 deposit and within 6 months it was to be executed. So the grant was my accrual of right. Well, that is my submission. The grant was my accrual of right under 2002 rules.
So state can't take advantage of its own wrong in delaying the process.
Well, in any event, I'll show section 56 of the Contract Act is not applicable in respect of a lease. It is covered by Transfer of Property Act, and the impossibility is embodied under.
That is a different argument. Will come to that.
Yeah, 100.
But first
that is now I'll come back to Rule 36. I'll try to be very short. Not repeat. Rule 36.
Yes, Mr. Banerjee's argument is that applies to.
That applies to only the mining lease granted under the rules.
2016 rules.
2016 rules. Now, you also kindly read it with me, my lord. Prospective license come mining lease holder or mining lease holder shall have rights as provided in the deed of prospecting license mining lease and deed of mining lease respectively. So far as the prospective license come mining lease, I am not coming. I am only coming deed of mining lease. Now, 2016 rules define only lease. The word lease has been defined. Come back to the definition.
Prospecting cum mining lease is also defined.
That is defined. Well, we are concerned.
It's a mining lease granted under these rules.
These rules.
So 2016 rules.
But kindly take the definition of mining lease under the 57 Act. Because these rules is framed under section 15 of the 57 Act. That book itself contains.
Yes, which section?
Section 2, 3D. Sorry, my lord. Yes, 3C. On the first occasion, I had shown you, lordship, prior to Puja vacation. As well as mining lease has been defined. Lease granted for mining.
For the purpose of undertaking mining operations.
Mining operations.
So how does this make a difference? 36 applies specifically to leases granted under these rules.
My lord, I'm just saying 36 says mining lease, not only lease.
This also says mining lease, deed of mining lease, Rule 36.
Rule 36 says mining lease. The words are mining lease.
The Act also defines mining lease.
No, Act defines only lease. The Act defines mining lease, but the rule defines only lease.
Definition of the.
Achha.
I'm sorry, my lord, I
understood, yes.
Act defines mining lease. A rule defines only lease.
But Rule 36 speaks about mining lease.
Rules for 36 speaks about mining lease. So it also saves, my lord, a right of any my lord lessee under any mining lease. That's my submission. Yes, you can. I have repeated it. It is word use mining lease.
36 says prospective or mining lease holder.
Or mining lease. I am concerned with only mining lease, not prospective
no,
like.
Shall have rights as provided in the deed of prospective.
Otherwise, there is no meaning of Rule 36 because it is well known that the right under lease, executed even under 2016 rules are, that is the right is granted to the lessees. It is not separately to be incorporated in the rules. But in fact, I could not show in the Rajasthan, in other states, the same rules were brought into after amending the earlier rules. Now they granted for 20 years.
But lease defines lease under Rule 2016 rules defines lease to mean a mining lease granted under these rules.
Yes,
so therefore that relates with mining lease.
There are two definitions of mining lease. One is in the Act.
The definition in the 2016 rules equates lease with mining lease. Mining lease granted under these rules. There is no separate. There cannot be two separate sets. One is mining lease, another is lease. Lease under these rules can only refer to mining leases.
Then, my lord, the word should have been used, my lord, not mining lease. It should have been used only lease because lease has been defined. It is for mining.
There is no definition of mining lease. Therefore,
mining no definition because it cannot.
Mr. Mr. Bandhavadar, mining lease in Rule 36 of 2016 rules cannot have a different meaning from lease. Otherwise, mining lease would be defined.
I'm not saying different meaning. I'm saying that these mining lease, these words, my lord, it can also, my lord, include the mining lease granted under the 2002 rules also, or even under granite conservation rules. I'll show the other provisions, my lord. Before that, my lord, kindly take section 15 of the Act. I'm sorry. Rule making section 56. I'm sorry, my lord.
15, 50.
Oh, 15.
16.
Can you take section 15 once?
Rule 15.
Section 15, my lord, under the Act. The state government may, by notification in the official gazette, make rules for regulating of grant of quarry leases, mining leases, or other mineral concession in respect of minor minerals for the purpose connected therewith. So state government cannot make a rules which will run. State government cannot limit the definition that it is mining lease only under 2016 rules.
Is there any place where in 2016 rules only the word lease has only been used? Yes, Rule 21 is there.
Yes.
All right.
Rule 23, amalgamation of leases.
Yes. 21 onwards.
Yeah, 21.
Chapter is leases.
Yes. These are my, so far as Rule 36 is concerned, these are my submissions. Section 56 now. Section 56, right?
Yes.
Prior to that,
Section 56
of the Contract Act. Prior to that, you will also kindly take the lease conditions so that I can leave the brief. Lease conditions, the renewal clause, page 102. Because he submitted that I had applied as per 2002 rules. What shall I do? Because otherwise my application would not have been accepted. Page 102.
Yes.
Clause 3 is the lease. First, the mining lease shall be renewable for one period not exceeding the period specified in sub-rule 1 of Rule 12 as at the options of the lessee. I'm just pausing here for a moment. Kindly take 2002 rules. Philosophy has got it. Sub-rule 1 doesn't prescribe any period. Sub-rule 2 prescribes period. Probably there is a mistake. Right? Has the philosophy got it?
Yes.
12.1 doesn't provide any period. 6 months prior to, then 12.2 is the period. Edit, no such renewal shall be granted for a period exceeding the period of original lease. But my period of original lease is 5 years. So I am only entitled for a 5-year failure, one renewal. Has the philosophy got it?
Yes.
Then proviso. I read the entire provided, however, the state government may refuse to renew a mining lease over the whole or part of the area covered by the original lease for which renewal is paid for. Yes, they have got the right of refusal, but that is on merit. That is on merit. What they did in the present case, they said it is not maintainable because of repeal of 2002. That was the order, precise order. 61, Rule 61 and Rule 62. And the learned Singular says that there was no grant. So 61 proviso didn't save your application for renewal. So it was not considered on merit. This consideration is consideration of my application on merit, not on this repealing.
Not on non-applicability of the renewal clause.
Non-applicability of the rules. Well, now, if the lessee or lessee be desirous of taking renewed lease of the premises hereby demised or any part or parts of them for a further term from the expirations of the term hereby granted, and is otherwise hereby
middle of that, the state government on receipt of an
state government on receipt of application shall consider it in accordance with Rule 12 and shall pass order as it deems fit.
So in accordance with Rule 12 was elaborated in that judgment. Yes. Mr. Banerjee says this goes by Section 56 operation.
Then I'll coming back. Then just I'm kindly just continue reading 3-4 lines. If renewal is granted, the state government will, at the expense of the legislature, executing and delivering the state government, if required, a counterpart thereof, execute and deliver to the lessee a renewal lease of the said premises or part thereof for the further term of 5 years at such rent, royalties, and on such and subject to such concern agreements, including in the present covenant, to renew and shall be in accordance with the West Bengal minor minerals rules on the day next following the expirations of the term hereby granted. My 2016 rule postulates 20 years lease. I cannot claim. It is always as per 2002 rules. And by virtue of the saving clause, read with section 6 of the general clause back. May I clear? Am I clear? Then, Malad, I am just drawing. So these Malad embodied in the lease deed, this renewal. Also, they are under the 2002 rules, that is protected by the saving clause and the section 6. But this is also embodied in the lease deed. Now, lease, Malad, it is a transfer. It's a registered lease deed, and lease is the transfer of property.
Is a registered deed?
It is registered.
Yes.
But beyond 1 year, lease it must be registered. So it is covered by transfer of property. Now kindly take section 56. Held by the Honorable Supreme Court. So far as the lease is concerned, section 56 cannot be separately applicable. And so I'll just take leave of my learned friend to show that since he had taken this issue. Agreements to do impossible act. First portion. There was no agreement, this lease or no agreement was done for doing any impossible act. Has you also got it?
Yes.
Then the contract do an act afterwards becoming impossible or unlawful. A contract to do an act which after the contract is made becomes impossible or by reasons of some event which the promisor could not prevent unlawful becomes void when the act becomes impossible or unlawful. Then, my lord, kindly see the illustrations. Your lordship will see the ambit of, my lord, section 56. Illustration is, my lord, part of the provision. A agrees with B to discover treasure by magic. That was an impossible act, the first part of section 56. A and B contract to marry each other. Before the time fixed for the marriage, A goes mad.
Thank God before marriage. Yes.
Probably we also got married before.
That is post. This does not apply. So the clause is binding.
Then A contracts to marry being already married to C and being forbidden by the law to which he is subject to practice. A must make compensation. That is the last part. Compensation, you also got it. That is the last part of section 56.
Yes.
A contracts to take in cargo for B at a foreign port.
So, but these are all contracts we understand, but Mr.
Yes, now this has been interpreted.
But they may argue that yes, the lease deed evidence the transfer of the title regarding the property. For that purpose, the lease deed is a transfer deed, definitely. But that clause where renewal clause is there, that is contract, that is an agreement incorporated in the transfer deed. This renewal clause is not a part of the transfer package.
Renewal clause is part of the lease. Lease. Now,
the transfer of interest.
Section 56 says
they may argue that
for severability. The entire contract will go.
Suppose there is a partition deed. In the partition deed, there is a prior refusal clause. That prior refusal clause may be constituted as a contract between the parties, and that can be specifically enforced in a court of law.
Yes,
so this renewal portion, although the lease deed evidences a transfer of title, but this renewal clause was not an essential part of the transfer. It's not a part integral to the transfer. Renewal is a clause which is in the nature of a contract between the parties incorporated in the transfer deed. They may argue this because similar logic, analogy with that partition deed containing a prior refusal.
I'm just coming. Section 56, in my even literal meaning also, it says that the entire contract will go.
That contract, no.
Renewal cannot constitute an independent contract. It's my humble submissions. It's a part of the contract itself.
No. As far as the renewal is contract, that's an agreement you enter into within the
That's part of the lease, that a part of the contract is a part of the contract. Section 56.
Part of the transfer, you are saying.
Part of the transfer.
Renewal is not an integral part of any transfer.
But renewal is my right.
There may or may not be.
Just
right by virtue of this clause or this statute, which is no longer there. Now, if you have a right to have a renewal, some future prospect, because transfer, Mr. Bandyopadhyay, can be only in presentee.
Suppose there is a clause of perpetual renewal.
Yes.
At the option of the lessee. 30 years perpetual renewal. So unless the contract is terminated for breach, the lessee will have that right as a part of the lease deed to get it renewed every 30 years. It cannot be separated. And now kindly take section 56 again. It speaks about the entire contract.
That clause may constitute an entire contract. Why not? It says an agreement to do an act impossible is itself is void. There are judgments that legal impossibility is also an impossibility. So,
legal impossibility, it becomes unlawful, not legal impossibility. This is
the judgment in our book immediately after that. We are quoting from that. Loop Telecom 2022 6 SCC 762 includes cases of legal impossibility, not limited to physical impossibility.
But it include cases of legal impossibility, not in respect of the lease. That judgment I'll show. And why I am showing? Because section 56, so far as the transfer is concerned, has been interpreted that only those circumstances which is the force majeure circumstances. Because why? Kindly take Transfer Property Act. If you, I think Kelasi has got it. Rule 12 is the reference. Renewal is the right accrued. Rule 12 is reference. Renewal is the right. Renewal of one term, 5 years. And that is not an impossible thing. Even if today, my learned junior friend argued that if it was executed prior to that, only on the basis that the lease was executed 2000, even if it was executed 2015, then then also this renewal would have been bad. It was impossible in 2020. He submitted that the distinction is my lease came into effect in 2019 because it was formerly executed in 2019. That is why it becomes impossible.
And we may have another argument that if it's only on the basis of statutory right, then they may even argue that it has become impossible by virtue of coming into force.
This is not only on the statutory.
Contractual.
Contractual.
If it's contractual, it's not impossible.
Not impossible.
It's just they physically have to renew.
That is
so
not an
contractual right.
That is exactly the same thing. The property, there's an instance that when a lease was executed, now the lessee could not get the possession. Because by dint of separation, by dint of partition, the land falls in a separate area. Even then the court said, no, this is not applicable. You are bound to pay the rent. Just show, kindly take 108.
That's your point, because if it's a clause in the contract, in the deed, it's a contractual, even if you construe this to be a contract. Now this contract has, renewal has not become impossible.
Yes.
By dint of this contract, it's not impossible. If it was only statutory right you are claiming, it would be impossible.
Yes.
Because your renewal, the renewal you seek, you may argue, is not on the basis of the statute now.
Not only because of the contract.
Of the act.
Because of the contract.
Clause, yes.
Because of the clause. Now kindly take 108 once.
That's an arguable issue, yes. You have to consider that. Yes.
Yes. In the absence of a contract or local uses to the contrary, the lessor and lessee of the immovable property as against one another respectively possess the rights and are subject to the liabilities mentioned in the rules next following, or such of them as are applicable to the property leased. Then kindly take E. If by fire, tempest, or flood, or violation of any army, of a mob, or other irresistible force, any material part of the property be wholly destroyed or rendered substantially and permanently unfit for the purposes for which it was laid, the lease shall at the option of the lessee be void. Even that was also at the option of the lessee, not at the option of the lessor. And this has been interpreted, this is the act of God, this force majeure circumstances in respect of the lease that covers section 56. 2, the second part of 56. This becomes only impossible if this happens. Now, just one judgment to substantiate my this argument. I have 2-3 judgments, but I'll just show only one judgment. 66. 53 নয় তার আরেকটা ছোটটা 68. All right, I'm relying on AIR 1968 Supreme Court 1024. This is on lease. That is why I'm just relying on this. দিয়ে দে কপি দিয়ে দে 108. I'm just only to refer certain facts, then. The appellant obtained, first page, the appellant obtained from the court of wards, Dadashiva Estate, a lease of 5 squares of land in Tahsil Okra district, Montgomery, in the undivided Punjab, for the Kharif season 1947 and Rabi season 1948. Following upon the partition of India in July 1947 and the allotment of the territory in which lands were situated to Pakistan, the appellants migrated to India. And actions commenced by the appellant against the Court of Wards in the Court of Subordinate Judge Kangra at Dharmasala such and such for a decree for refund of the rent paid by him was decreed. But the High Court of Punjab reversed the decree, holding that the doctrine of frustration of contract did not apply to the leases of immovable property, and that in any event of the facts provided, there is no case of frustration established by the appellant. With the certificate granted by the High Court, this appeal is preferred by the appellant. Then Malad kindly take paragraphs 12, Malad first. First, Malad, 9, Malad. I'm sorry, Malad. Extremely sorry.
9.
We are unable to agree with the counsel for the appellant in the present case. But appellant, Malad, who lost before the High Court. That the relations between the appellant and the respondent rested in a contract. It is true that the Court of Wards had accepted the tender of the appellant, had granted him lease on agreed terms of the lands at the other side, but the rights of the parties did not, after the lease was granted, rest in a contract. By Section 4 of the Transfer of Property Act, the chapters and sections of the Transfer of Property Act which relate to contracts are to be taken as part of the Indian Contract Act 1872. I'll just show the Section 4 of the Transfer of Property. That section, however, does not enact and cannot be read as enacting the provisions of the Contract Act are to be read into Transfer of Property Act. There is clear distinction between a completed conveyance and executory contract, and events which discharge a contract do not invalidate a concluded transfer.
Yes. Your learned juniors found out this judgment? How do you found it?
My learned junior.
Yes. Very good work.
I'm grateful to them.
Yes.
By the express terms of Section 56 of the Contract Act does not apply to cases in which there is a completed transfer. The second paragraph of Section 56, which is the only paragraph material to cases of this nature, has a limited applications to the covenants under a lease. A covenant under a lease to do an act which after the contract is made becomes impossible by reasons of some event which the promisor could not prevent unlawful become void when the act becomes impossible. But on the account of transfer of property act resulted from the lease granted by the lessor to the lessee is declared void, is not declared void. Is it this because
the answer to the question which you asked?
Yes. Transfer of property act when comes into play, section 56
culminates in transfer, then it's
section 56 has no application. I can read other
para 12 is also as you have
para
cited.
12, then para 17.
Yes.
Because the contrary case was cited of, then it was also dealt with
categorically. Yes.
And in any event, on a literal term, they can execute renew a lease up to in 2020 only because the lease executed in 2015.
I'm frankly telling you why I asked you the question, because in my mind was also playing these arbitration clauses.
Yes.
Now the language in the Arbitration Act is section 7 says it may be an arbitration agreement. It's an arbitration agreement. So arbitration agreement may comprise
that constitutes a separate contract
or a contract in a
now if you constitute in that, if there is no such provisions under the Arbitration and Conciliation Acts, it would have been difficult for us to constitute that arbitration clause itself a distinct contract. Because of that provisions,
it may act otherwise also, as you were saying. For that reason only that provision was introduced.
Because there are judgments, your lordship is aware that when the arbitration agreement, the court says this agreement is void. There are contrary judgments. When it voids, so it goes. But subsequently, Supreme Court clarified, no, because the arbitration agreement is a separate contract, even it.
There is a line of reasoning for the later.
Yes, the entire the contract is void. That will survive for the purpose of.
It's taken to be a different contract.
Yes, for the purpose of adjudication dispute. So, because of these particular provisions on the Arbitration and Conciliation Act, that constitute a different contract.
This answers that also.
This answers that. But one thing, your lordship's judgment, I'll just show only two paragraphs. That was clear. I would say, since this is still the good law, the last judgment, Nityananda Pal, 38-39. From 38. From 37 onwards. I had probably handed up the copy.
Yes, you had. Para 37.
37 on page 12.
Yes. Yes.
Now, an interesting argument has been made in this regard by the respondents to that effect, that since clause 3 centers around reference to the Rule 12 of 2000 rules, which rules themselves had since been repealed on the date of filing of the renewal application, whether the said clause could be relied on at all. So it was not at all that what Mr. Banerjee is now arguing was not argued in this case. In that case also it was argued, but not on the basis of section 56 or otherwise. Then, however, a careful construction of clause 3 of the lease deed shows the right of renewal conferred therein does not purport to be under Rule 12, but in accordance with Rule 12 of 2002 rules. There is huge difference between a clause deriving authority directly under a particular statute rule or provisions of law and a contractual term being in accordance with the said provisions, as I just argued. This right is also flowing from my contract, and which is undefeated, at least to get my renewal application considered on merit.
So once it's incorporated, the repeal of that statute may not have any bearing. Because the right of renewal now is on the basis of the contract.
And that is exactly your lordship has held. And there is no exactly. I can go on reading.
No, we faintly recollect. Yes.
Exactly your lordship held. And your lordship gave the benefit under 62(2). And your lordship didn't specify section 6 of the General Clauses Act. But even if it was for the timing, I forget that no, I will not get the benefit section 36, but I am protected.
36 was not argued or dealt with.
Not argued. I am otherwise protected by 62(2), read with clause section 6. But your lordship says unless the provisions of General Clauses Act is specifically excluded, in repealing. Section 6 shall always apply. Well, there are 3 judges bench, 4 judges, constitution bench judgment, I need not repeat it.
That is why it's a General Clauses Act. Otherwise, it would have no meaning if it does not apply by default.
Yes, it is to be specifically excluded. Or a specific contrary intention.
Exactly. Specific contrary intention.
That is section 6 itself.
Section 6 itself, yes.
But these rules doesn't appear there is any contrary intentions, that no, section 6, all provisions of section 6 shall not be applicable. These are my submissions.
Only thought rejoinder, because new actual submission has been made that the grant which was given, that itself should be treated as a lease, because a period of 6 months is prescribed in the rules.
That and this judgment.
And this judgment. Now, on the submission that under Rule 15, 6 months is provided, I would request you to kindly come to the Rule 1. It has also an exception.
15. 6 months of consideration of the application. No.
Rule 15 says, when an order has been made for the grant of a mining lease, the deed of lease shall be executed within a period of 6 months from the date of the order granting the lease, provided that the state government or the officer so authorized by it may permit the execution of the deed of lease after the expiry of the aforesaid period of 6 months, if it is satisfied that the applicant is not responsible for the delay in execution of the deed of lease. Now, Lordship will kindly read this with Rule 5.5, which is a special rule for me, Lord. Leases for stone and granite. Rule 5, sub-rule 5.
This is stone and granite.
No, this is
blackstone.
Blackstone. Not
granite.
Granite, there is a granite.
Stone also, stone and granite also, both.
Now,
the central rules.
5.5 says, Rule 5.5.
Yes.
In case of stone and granite, on receipt of communication from the state government of the precise area to be granted, the applicant shall submit before execution of the lease deed the following document: A duly approved mining plan prepared by the recognized qualified person. B, a clearance certificate, no objection certificate from the competent authority for use of explosives. These are to be submitted. Now, in the lease grant letter also, page 76 of the...
Subject to this.
Is subject to, Willard, subject to all the terms and conditions. Kindly come to page 76.
You have not refused on that ground.
No, he is saying that the grant immediately should be treated as the initiation of the lease deed.
Yes.
But grant is subject to fulfillment of the conditions.
But that you have to do within 6 months.
6 months or extended period, we can permit it, provided he shows that he was prevented by sufficient reasons. He has submitted those things in 2018. I'll show that. Environmental clearance. He has given in 2018.
Which page?
Clearance is that page.
Which page of the...
Page 14.
Page 14.
And my submission was, by right was accrued by grant.
No, 40
Page 40.
No, there was delay. I admit that there was delay at the both instances because I applied. Now it is the state government who should give the environment clearance. Ultimately, they delayed the grant of environment clearance.
When did you apply for that?
80,
within time, sir. All applications are within time.
Applied for?
Applied.
He has submitted.
Submitted.
You gave him late.
It is not his case, my lord, that he has applied, it was late. What is the reason, my lord? Then he'll have to make out that case.
I have pleaded.
Which is page?
Page 80, 4/4/2018. This is one of the requirements. I can show at least this date that he has submitted it as per the grant on 2018, April 2018. And there are other requirements also he has to fulfill. And the lease is subject to these statutory requirements. So we cannot say that
automatically 6 months.
6 months, automatically after 6 months, the lease will start to run. Because if not that submission is taken, my lord, then the period of lease, if it starts from a period after 6 months of the grant, then 2013, 2018, it has expired. If we take the lease to have started from 2013, case, his application is not incompetent because it has to be applied before 6 months prior to the date of expiry of the lease. If that is the submission that it should start from the date of grant.
No, I didn't say that. Renewal application is to be submitted prior to 6 months, prior to expiry of 6 months. That was submitted exactly.
No, I say
my lease was supposed to expire in 31st May. I applied in October.
I say that if his stand is that the grant amounts to initiation of the lease. That was the submission.
I
made.
said grant is my accrual of right.
Grant is accrual of right upon fulfillment of conditions to get the lease executed, but not non-fulfillment of the period of 6 months. That doesn't mean that for our fault the submission was made, that because of the inaction of the state in granting it within 6 months, it has gone on to a period after 2016. That is not the case.
Yes.
After fulfillment only lease shall be granted. So lease is not separate. Execution subject to fulfillment. And lease grant also says you have to fulfill these conditions, then only it shall be granted. And 6 months is not mandatory. It can be after that period also, which has been given to him. Now, my lord, the other submission is that my lord, Contract Act doesn't apply, my lord, to cases of a transfer of property. Now, my lord, his submission initially was relying on these other judgments, where my lord, your lordship has relied on the contractual rights. Now, if not Contract Act has no application, because he can claim either under the rules or on a contractual right. If in case of a transfer of property, Contract Act doesn't apply, has no application, then the other limb of his submission that contractually also I have a right of renewal, can he claim that, unless it's a contract, 56 will not apply, then Contract Act as a whole will not apply. Then what is this clause? Because then it becomes either it's a rule or the contract, and Contract Act doesn't apply. He will have to elect under which he has elected the rules.
Para 12 of the judgment is cited now says authorities in the courts in India have generally taken the view that Section 56 of the Contract Act is not applicable. When the rights and obligations, the rights still arise. Rights and obligations of the parties arise under a transfer of property under a lease. So it arises not from a contract. In our judgments, we had held that contract. The term contract was loosely used. But here it says it's a right or obligation arising out of the transfer. So even if you replace that word contract with transfer, I mean, it's a right and obligation arising from that document. It's a documentary right and obligation, not a statutory right and obligation.
Transfer. It is not a transfer of property. It's a transfer of right of enjoyment.
Transfer property, by definition, it's a transfer property.
Right, because possession.
Transfer property does not necessarily means that entire bundle of rights of ownership.
Ownership doesn't go. Possession and the right of enjoyment.
All transfers contemplated under the transfer property are by definition transfer.
Lease is a transfer.
Lease is a transfer, exchange is a transfer, mortgage is a transfer.
Ownership, but possession along with the right of enjoyment.
Now, limited rights, not the entire bundle of ownership rights.
So if the right flows from the grant also, lease deed also,
then it does not. This judgment is very clear that rights and obligations arising from a transfer are not covered by Section 56 of the Contract Act. That is the difficulty you have to. This is a hurdle you have to cross.
Comes to an end.
Or we have to cross if you are satisfied with your submission otherwise.
This judgment for the first time I am encountering this proposition. I don't know whether any further judgments on this point are there or not.
That my lord will search.
Because 56 in that event, 56 argument I cannot make. But the
rest of the
main argument that the application made under the rule.
The other arguments remain.
Application made under the rule and from his application itself.
Replace your arguments on contract with the deed.
With the deed.
The transfer. As in our judgments also.
If it is the principle. 56 might not apply, the principle will apply. That if the rules go, then who shall consider? What shall be considered? Everything is gone. These are my submissions.
Put it in a nutshell in a written notes of argument, because we want to keep something on record so that we don't miss anything. This is going on for some days. We have taken exhaustive notes, no difficulty on that. But we don't want to take a chance that we miss out something.
Get any subsequent judgment on this, we shall just put it in the note and I'll give a copy to Mr. Bandhavagh.
But then he cannot deal with it. He won't have a. We'll keep another date for this.
For submission of the notes.
For submission of the notes, if you find something distinguishing this or
this judgment
on this judgment, you put it in the notes and give advance notice to Mr. Bandhavagh so that he can put it in his notes, whatever he has to say on that. So we'll give you 1 week. You do it as early as possible. He has to do it by tomorrow, and you will check it over the weekend and give it to me, sir. And his competent juniors, they have been given a certificate, so they'll do it within a day also.
Exchange of notes.
Exchange of notes. Yes, otherwise, how can they know? So very well. And don't fight over who will exchange first. Here, oral arguments are concluded. Full stop. The matter will be listed on today we are on 4th, so we are giving you Monday week so that you get some more time. 2 weekends, 1 weekend for you and 1 weekend. The matter shall next be listed on December 15, 2025 under the heading to be mentioned for the purpose of filing of written notes of arguments by the parties, which will be exchanged between themselves in the meantime.
Grateful.
Thank you very much. এখন তো পাঠাতে হচ্ছে না কেন এগুলো না একটুখানি নোট আমি সরি এটা একটুখানি Yes.
না সামার ভ্যাকেশন না দুর্গা পুজো
The Lordship heard this matter on last
Yes, you remember, but
18th September.
But you just give in a nutshell for my brother. In a nutshell, we'll do because we'll take written notes ultimately.
But Beleranga 2 Panchayat Samiti is the applicant, Your Lordship. But 6 ferryguards has been entrusted to Doom, including Narkelbari ferryguard.
Yes.
By virtue of 2 government circulars dated 7th March 1979 and 22nd of June 1987. These are the 2 notifications.
One you handed over, one you handed over.
Yes, I have handed over one because hearing was concluded on that day at this junction. I'm handing over another price.
87
You are for the state.
my learned senior Supratima
Dhar. His name is Dhar. Full name is Supratim Dhar.
Yes, Dhar. But engage before another court, my lord.
Mention before that court and say that this bench is taken up so that the bench releases Mr. Dhar. Yes. Don't do that. You sit here. Mr. Dhar has heard him on the last occasion, so he'll know what is happening.
Another circular. I'm relying on later on. But since 1987, all these 6 ferryguards are being maintained and controlled by the Beleranga 2 Panchayat Samiti. Why
you are there on the state panel? You take notes, whatever he's arguing. Yes. By the other notification, Mr.
I have handed over.
Yes, 22nd June.
By settling all those 6 ferries, my lord. E-auction to the public ferries. Can you take up my stay application? Some documents showing running of these ferryguards from 1987, but I have taken charge present Panchayat Samiti in the year 2019. So let me kindly come to first page 42. The auction notice of 2019.
Panchayat Act to bar kore
Page 42 is the one of the
auction notice in respect of Narkelbari Ferry Ghat. Auction invited on 15th February 2019. Then 46. I have given all the 6 ferry ghats, all auctions.
Yes.
Page 46 is next year, page 2020. Narkelbari Ferry Ghat. Then my lord, straight away come to page 76. All 6 ferry ghats we are continuously running. There is no doubt.
Hmm.
The last such auction has been conducted in respect of Narkelbari Ferry Ghat on 29th of July 2024, page 74.
And,
or 1 term.
Right.
But now your lordship straightway kindly come to page 125. Notice inviting tender, Narkelbari Ferry Ghat. Page 131 is the work order. I have annexed all 6, but I am placing before lordship only Narkelbari.
We are bothered with Narkelbari only.
Yes. This is 25th September 2024. Grant of temporary permit, page 131 of Narkelbari Ferry Ghat with effect from 1st October 2024, 30th September 2025. Now the next page is the order impugned.
Yes.
Issued by the District Magistrate Collector Murshidabad. At page 132, this is a intimation of 17th July 2025. The District Magistrate written it to the District Executive Officer to Panchayat Samiti. So that is the Beladaga to Panchayat Samiti addressing the Executive Officer.
Panchayat Samiti was granting you this.
No. The circular says the government will hand over these ferry ghats in respect of jurisdiction of Panchayat Samiti to the Panchayat Samitis. If one ferry ghat is fallen in 2 Panchayat Samitis, then it will go to the Jila Parishad.
All right.
And if it is a small in Gram Panchayat area, then it will be executed by the Gram Panchayats.
Samiti.
No, Gram Panchayats.
Achha.
First Gram Panchayat, if any ferry ghat is fallen 2 Gram Panchayats, then it will be Panchayat Samiti.
And so on.
So on. If 2 Panchayat Samiti, then Jila Parishad. Now kindly see my lord, 17 July 2025. Our executive officer has been addressed subject restraint from further settlement of Narkelbari Ferry Ghat by Beladaga to Panchayat Samiti. Subject.
This happened after this grant to you.
Yes. Continuing. I have shown to your lordship.
This grant is still continuing. No, it has ended on.
It was 1st October 2024 to 30th September. Before 30th September, this communication has been made.
Yes.
It has come to the notice of the undersigned that Narkelbari Ferry Ghat has been settled in favor of Shakti Chamocho Mill by the Beladaga to Panchayat Samiti. This act of settlement is irregular and constitutes an overreach of jurisdiction. As per Rule 281 of the West Bengal Land and Land Reforms Manual 1991, it is categorically stated public ferries and non-public ferries.
Oh, you are the Panchayat Samiti who is challenging?
Yes. The decision of the district magistrate is challenging by the Panchayat Samiti.
So on a higher footing, not the person who got it.
No.
Very well.
The person who is running, he is not before your lordship. The Panchayat Samiti who is.
You are on a higher footing because you don't have any personal interest here.
Yes. I'm grateful, lordship. The act of settlement is irregular and constitutes an overreach of the jurisdiction. As per Rule 281 of the West Bengal Land and Land Reforms Manual 1991, it is categorically stated public ferries and non-public ferries, ferries which has been declared as public ferries under the Bengal Ferries Act 1985 shall be exclusively under the control of the district magistrate, subject to the direction of the commissioner. It is pertinent to emphasize the statutory use of the word shall, which denotes a mandatory provision. Moreover, this is very important. As per Section 110 of the West Bengal Panchayat Act 1973, the management of any ferry may be entrusted to a Panchayat Samiti only if such power of delegation delegated by the state government, and that too, this is very important, that too with the approval of the cabinet. Take note of this sentence specifically. Approval of the cabinet is required according to the district magistrate. In the absence of such explicit approval, no authority lies with the Panchayat Samiti to undertake such settlement. In the absence of explicit cabinet approval, the said settlement stands in contravention of the prescribed rules of business of the state government. It is therefore directed that the practice of holding tender or entering into settlement for such ferry carts by the Panchayat Samiti must cease forthwith. As such action are in clear violation of the West Bengal financial rules and may lead to potential losses to the consolidated fund of the state, besides amounting to diversion of public revenue. Well, this is the intimation to the executive officer. Now, Your Lordship, kindly to come to page 137.
Yes.
Subsequent thereto, a tender has been floated through the additional district magistrate, which will appear from page 137. This is 20th of August 2025, only in respect of Narkelbari ferry ghat. I am repeating, all the 6 ferry ghats fallen in the same provisions of law, but in respect of other 5, now steps have been taken. Only Narkelbari ferry ghat.
You have different color or something?
No. All are, no, that color I have also shown. In other Panchayat Samitis, nothing has been taken. So far I am concerned, I am running 6. Out of that, only Narkelbari ferry ghat has been targeted. I don't know why. Now, Your Lordship, kindly see. This is for general information that Narkelbari ferry ghat with consecutive general so under the subdivision Bonampur, Sodor in the district of Murshidabad, which is under settlement process of the district land and land reform officer Murshidabad, will be settled for the period of next 3 years through online mode of bidding in the government e-auction portal so. Kindly see, my lord, serial number 8. Auction financial so. Auction financial so 5 p.m. The date has been given 15 September and 16 September. While the person concerned who has been entrusted, he was running the business, running the ferry carts. Now, Your Lordship, kindly come to page 143. This has been issued by the want to show before additional district magistrate and district land and land reforms officer at page 143. We took a resolution.
143.
143 is a signature.
Yes.
I want to show district land and land reforms officer and the additional district magistrate. He issued this tender. Now, page 145. The description of the ferry ghat has been given. It is a part and parcel of the tender notice. Narkelbari ferry ghat, Beladanga 2. One thing is that while the person concerned who was running, he was continuing at that material point of time. Then the Panchayat Samiti took a resolution. Kindly read, my lord, page 147. And that has been forwarded by the executive officer Beladanga to Panchayat Samiti, addressing to the district magistrate, saying, page 147.
Yes.
I am sending where is the copy of the resolution approved by the meeting of the Artho Sanstha Unnayana Parikalpana Samiti of the Beladanga to Panchayat Samiti held on 13th August 2025, which is self-explanatory and proposed for reconsideration of the order in respect of Narkelbari ferry ghat issued on so and allow the Panchayat Samiti to manage and control to the ferry ghat as usually for the next so years and so on. Well, this has been written by the executive officer, and the resolution of the Artho Sanstha Science Samiti will appear from page 133.
Yes.
Need not go through the entire document, my lord. You will have to kindly come to 2-3 paragraphs I shall read. It starts from page 133 is the signatures of the members. Then 134 contents of the
134.
Yes, my lord, the Bengali resolution. I will adopted by the Panchayat Samiti and forwarded by the executive officer. 134, 135, and 135 is the minutes of the meeting. I will Bengali.
Yes.
Saying therein that out of 6, why you are taking so? In terms of the law, we are
This is your resolution.
My
resolution.
My lord. Now, Your Lordship, kindly see the law, provisions of law. First, Your Lordship, kindly see section 110 of the Panchayat Act. I'm handing over.
No, we have
Both book, 2 books, my lord.
two books for one for each of us.
Yes, Mr. Hara has started.
Look at the expression on your left. And then if you don't feel sorry, then leave.
I wanted to say, the maintainability of the writ petition aspect has to be taken into consideration as well. Because
why not indicate and he'll address that also.
The order impugned before the writ court is under West Bengal Land Reforms Act, which is a specified act, and section 6, 7 and
writ court has allowed it or rejected?
No, writ court has only stated this is this is a
because their writ petition.
Yes, this is a dispute amongst the two functionaries of the state, because one is Jilla Parishad, another one is district magistrate. I am asking the principal secretary to mediate. Only
So
that.
Mr. Shara will meet that also. Well,
but I hope Mr. Shara will address on that aspect as well.
We also hope.
And the order passed. This is from an interim order. In the letters patent appeal, kindly consider that aspect as well.
Interim order is not appealable.
Appealable, where any right of any of the parties has not been even touched.
What was the interim period? That was
only the learned single judge has said the highest authority. The one is the Panchayat, Principal Secretary of Panchayat, as also the Principal Secretary of Land will mediate this aspect, since two functionaries of the government are at loggerheads.
So no rights have been decided?
No rights have been decided.
Very good.
And may I give first answer to that, my lord? Or
better.
Kindly come to the impugn order, page 162. 162.
Interim order needs to be named. Yes.
The affidavit of service as filed today on behalf of the writ petitioner is taken on record. On perusal of the petition under consideration as well as dependent notification as placed before the court, Mr. Swanso learned senior appearing on behalf of the writ petitioner, it prima facie appears to this court that the instant writ petition arises on account of some misunderstanding between two functionaries of the state, that is the Sahabhati Beladanga 2 Panchayat Samiti, the writ petitioner number 1 herein, and the respondent number 4, that is the district magistrate and collector Murshidabad. Though in the instant writ petition, the memo dated so-and-so as floated by the respondent number 4 authority is under challenge at the instance of the writ petition. However, it appears to this court that it would be appropriate if the Principal Secretary, Panchayat and Rural Development
So
Department.
you are relying on para 5?
Yes.
Para 5.
Page 162, paragraph 3.
You are relying on para 5 to say that it's an appealable?
Yes. Then, my lord, kindly turn the page. Secretary Land and Land Reforms Officer, Refugee Relief and Rehabilitation Department for setting the dispute in so-and-so. In view of the such, the Principal Secretary, Panchayat and Rural Development and the Principal Secretary, Land and Land Reforms and Refugee Relief and Rehabilitation Department are directed to hold a joint meeting positively within 15 working days from the today, and the minimum of the such meeting shall be left to be placed before the court by the learned advocate for the respondent state on the adjourned date, that is on November 6, so when the instant matter will be listed under the heading adjourned motion. In view of such, this court finds no reason to pass an interim order as prayed for at this stage. Learned advocate for the state is requested to communicate this order. But there is no whisper that my learned friend has taken any plea regarding the maintainability of the writ petition. At least writ petition has been admitted. Direction has been given with a certain authority to do this and submit a report. Matter is still pending. So at the threshold, on the ground of maintainability, it has not been rejected. No point has been raised.
And what about not being appealable? This order not being appealable as an intra-court appeal?
Refusal to interim order. Paragraph 5, in view of such, this court finds no reason to pass any interim order as paid for at this stage. Tender has been floated. Date has been fixed when I came before this honorable court. Before conducting tender, I came before this honorable court for praying for an interim order of stay, not to hold the tender. That has been refused. Now, Your Lordship, kindly see the order passed by Your Lordship on 18th September.
Yes.
Hard learned senior counsel appearing for the applicant due to paucity of time, the hearing cannot be concluded today. At this juncture, learned senior counsel seeks an early hearing of the matter in view of 30th this month being the last date of tenure of the present entity which is running the disputed ferryboat at present. However, learned senior counsel appearing for the state submits that in the meantime an e-auction has been failed and as such the apprehension of the appellant is unnecessary. Be that as it may, let the matter be treated as part heard and be placed in the list on September so and so for further hearing. Learned senior counsel appearing for the state further submits that as per his instruction, no fresh auction shall be initiated before the month of November 2025. On the basis of such assurance, we are not granting an interim order. No whisper about any challenge regarding maintainability of the requisition. Rather, I think, well, this is an interim order to some extent on consent. That since we are not going to hold any auction in the meantime, Your Lordship declined to pass an interim order. No point has been raised. So far this point is concerned, possibly at this juncture, my Lord, they cannot take. While the matter is being treated hard in part for final hearing,
if Malad permits, Malad, on maintainability issue, may I answer this? Because I think Mr. Shahrai will go into the merit of this matter.
I am already in merit. Anyhow.
He is in the midst of merits. You give in a replay compositor. You're already, it was part heard. And now we are at the hearing stage also. So now we'll hear you on the question of maintainability, but we'll not stall the hearing for that.
That's section 110 of the Panchayat.
110.
State government may place other property under Panchayat Samiti. The state government may, from time to time, with the consent of the Panchayat Samiti, place and road, bridge, ferry, channel, building, or other property vested in the state government and situated within the block under the control and management of the Panchayat Samiti, subject to such condition as it may specify, provided that the state government may, after considering the views of the Panchayat Samiti, withdraw such control and management to itself, subject to such condition as it may specify. I have shown to Your Lordship, the impugn order says approval from the cabinet is mandate, and for that sole reason, it has been taken away.
That is in bold letters in the order.
Yes. If Your Lordship once again come for my satisfaction.
You're already, you should be satisfied by it. Because you have seen it is in bold letters.
So 110 never says cabinet approval is required. Yes. In the bold letter, it has been stated that too. In explicit manner, it has been recorded that the approval is mandatory. So, my Lord, so far 110 is concerned, it said that state government may, from time to time, with the consent of the Panchayat Samiti. So,
cabinet sanction is required. I have not seen in any statute as such.
I don't know, my Lord. And bold letter, that too. One second, my Lord, just see, my Lord, what is the language?
No, we have, I remember. On the last occasion also you placed.
Yes.
That's why we remember.
So this is my one point, provided that the state government. So after obtaining consent from the Panchayat Samiti, respective Panchayat Samiti,
yes,
it may be granted to the Panchayat Samiti for maintaining of the same in terms of 110. The other provision which has been relied on, the land manual.
So this rather says that with your consent, it can be placed under your control.
Yes.
And it can be withdrawn with your consent also.
Yes.
Subject to withdraw such control after considering your views.
Yes.
It's the other way around.
Yes. And in this case, nothing has been intimated. No hearing, no show cause, nothing. Straightway cancellation during the tenure running by a person.
And that is done by a district magistrate.
And
not
district
the government. Not the government.
Not the government. My Lord, in the order impugn also relied on 280 on the land manual. This is my copy. I'm handing over the land manual. I'm handing over.
The land reform, what?
This particular provision, my lord.
No, let us get the act.
My lord.
ঘুরে দাঁড়িয়ে গেলে
Land manual. No, land
আছে আছে আমি জানি আছে
because invariably when you show something, Mr. Dhar show some other provision.
Land matter.
Have the act.
Land matter.
This is section
281. They have relied on. They have
281. আছে এই অর্ডারটা কোথায় গেল?
No, this is the provision, but they have emphasized, my lord, 110 section first.
Yes.
Now the two notification which I have placed at the very initial
Financial
stage
rules you are saying manual আছে
manual.
এটা ম্যানুয়ালটা এতে আছে কি? ম্যানুয়ালটাও ছিল আগের বার, ম্যানুয়ালটা এতে নেই। ল্যান্ড রিফর্মস ম্যানুয়াল একটা আছে, এইটাই হিয়ারিং হচ্ছিল যখন তখন আনান হয়েছিল। এটা পঞ্চায়েত কি ম্যানুয়াল দিয়েছেন?
Because actually they have relied on, my lord, section 110.
110 primarily.
Yes.
And 281 আছে।
Right.
Yes, public ferry.
So, my lord, now that notification I have placed before lordship, just your lordship kindly take up the first one, dated, my lord, 10th of September 2025. Sorry, my lord, 7th of March 1979. The last occasion I have the additional copy also.
No.
Have you also got it? 7th March.
Yes, yes.
Kindly take note. Making over all cash and vested tanks and ferries to the Panchayat institutions. In accordance with the decisions taken by the Cabinet Subcommittee on Panchayat institution for the transfer of cash or vested tanks, huts, bazars and ferries to the Panchayat bodies for their control and management, it has been decided by the Board of Revenue that the following steps should be taken for the quick implementation of the decisions. Your Lordship need not go through the same. It is in respect of Gram Panchayat. Next page. Roman 6. In case any cash or vested tanks whose jurisdiction extends over more than one Gram Panchayat, such cash or vested tanks should be handed over to the Panchayat Samiti. Should be.
Give a copy to Mr. Dhar.
Then Roman 7, cash or vested tanks extending over more than one Panchayat Samiti should be handed over to the Jila Parishad, which I have submitted. And next one is the Panchayat Samiti is list of vested series. Kindly read.
Roman 6 applies to you.
My lord. Roman 6 and then, my lord, Roman 7. 8. In respect of vested ferries, Panchayat Samiti wise list of such ferries in respect of which the issue of the settlement expires on the last date should be prepared immediately and such ferries formally handed over to the respective Panchayat Samitis. If government's continuing on before expiry of the same, it should be handed over to the respective Panchayat Samiti. A complete Panchayat Samiti wise list of vested ferries whose terms expire on subsequent years should also be prepared immediately, indicating against each of the date of expiry of settlement so that they may hand it over to the concerned Panchayat Samiti on time. So, a lease is going on, holding by the government. In the meantime, this notification came into picture. In that case, a list will be prepared and hand over to the Panchayat Samiti so that from the next term, they can conduct the tender. A list wise. And the next circular, if you will kindly take note of the subsequent one. 22nd June 1987.
You gave today?
Yes, just no, monthly to সকালে একবার।
সকালে দিলেন ঠিক?
হ্যাঁ, দিয়েছি।
শুরুতেই দিয়েছি।
3 একটা
Except you, they are giving to everybody.
He was not present, my lord, at that time.
Injustice. No, you gave today only. Today you handed over when you started.
Yes, he was not present.
Oh, then he was.
I didn't get any opportunity to hand over.
No, his learned junior was there, not Mr. Bhattacharya.
I'll not to go to that effect.
And he was very shocked at your citing of this.
But kindly see, this is dated
22nd June.
22nd June 1987. In exercise of the power conferred by Section 13 of the West Bengal State Acquisition Act, West Bengal, Rule 12 of the West Bengal State Acquisition Act 94, the governor has been pleased to order as follows. All khas and vested tanks and ferries belonging to the state shall, subject to the rules for the time being in force and subject to the directions issued or may be issued by the government from time to time, be managed by the Gram Panchayats under whose respective jurisdiction the said tanks and ferries are located. In case khas or vested tanks or ferry falls under the jurisdiction of more than one Gram Panchayat, the same shall be managed by the Panchayat Samiti under whose jurisdiction it falls. And in case such a tank or ferry falls under the jurisdiction of more than one Panchayat Samiti, the same shall be managed by the Jila Parishad. The khas and vested tanks and ferries which are under valid license granted to the collectors shall be managed by the Gram Panchayat, Panchayat Samiti or Jila Parishad as the case may be on expiry of the existing term of the said lease or license. The khas and vested tanks and ferries which were handed over to the collectors, to the Gram Panchayats, Panchayat Samitis, Jila Parishad as the case may be, in pursuance of memo dated 7th March 19, I have placed before Lordship, the previous one. The Board of Revenue, Government of West Bengal shall be deemed to have been always managed and shall continue to be managed by the respective Gram Panchayats, Panchayat Samitis or Jila Parishads on and from date on which the said tanks and ferries were handed over to the by the collector. But this is have been always managed and shall continue. So this is my case in respect of the law is concerned. In addition to that, this Panchayat Samiti running these 6 ferryguards from 1987.
You also have to delete 281 of the
manual.
That has also been quoted.
Yes. So
regarding the other aspects with you.
So for manual is concerned.
Yes. 110 is obviously what you said. This notification there.
Manual.
Manual 281 is just contrary to what you are saying.
Yes, just contrary to.
No, but what is the source of power of the manual? I mean, source of authority of the manual? We don't. I don't know that.
Which book is it?
Executive instruction.
Executive. Just a minute.
That gives your answer. You say.
I dispute that. Well, this is.
You dispute your own counsel.
Coming from the West Bengal Land Reforms Act, Section 60.
It don't be so dramatic. What is the section?
Section 60 and 62.
It's an interstate dispute. We are not into that.
Section 60 and Section 62. Kindly come to Section 60 and Section 62 first.
Not to make rules, yes. It's not quoted.
Section 60
quoted in the manual itself. In the manual itself, it's not stated that we derive power.
It is
under this provision.
Yes.
Where?
I'll take your lordship.
Where will only come to you. Because you wanted to put Mr. on notice so that he can.
From the manual, it does not appear. From the introduction part, nothing is there. Only says government policy. Government policy.
Yes. That is what you saw here.
Yes. And this is, your lordship knows, 1991.
Principles and procedures to be followed by officials and functionaries in matters relating to land and land reforms. Also embodies government policy in matters relating to management and settlement of government lands. Overriding effect is given also.
Overriding effect, the provisions in the law, section 4, introduction.
But this cannot override any statute.
Absolutely. Absolutely.
Executive action cannot override.
In any manner.
If it's government policy, Mr. Sengupta is for a change, he is right.
No, whatever may be, it cannot override effect have to so far the statute is concerned. I am talking about Panchayat Act, and that too, my lord, the district magistrate also kindly see, my lord, proceeded particularly on the section 110. And more,
yes,
and more so the bold portion.
Now, Mr. Dhar is saying section 60 and 62 of the Land Reforms Act. You have to connect the two.
Land Reforms Act.
Land Reforms Act 62 is state government may give such directions not inconsistent with the provisions of this act, etc., as may appear to the state government to be necessary for carrying out the purposes of this act or any rule made thereunder. But this is governed by the Panchayat Act.
Panchayat Act.
Anyway, he'll have his say when he comes. Yes. So what is your answer to these rules? Rule 281. Because that was also quoted in the impugned order.
Rule 281. Rule 281, once again, if you actually kindly come.
That is apparently against you.
To some extent, ferries which have been declared as public ferries under the Bengal Ferries Act shall be exclusively under the control of the district magistrate, subject to the directions of the commissioner. Kindly take note of subject to the directions of the commissioner. These are now under the administrative control of the Public Works Department. Other vested and auxiliary ferries will be governed by sub to so and so. But subsequent thereto, before that, well, kindly take note of the notification, two notifications.
This is a public ferry, declared to be a public ferry. We don't know. This applies to ferries which have been declared as public ferries under the Bengal Ferries Act. Regarding other vested and Khashmohal ferries, those will be governed by 228.
Two notifications. In my reply, I have categorically stated. Not public ferries.
This probably is the Mr. Dhar was relying on because of the 281 Roman 2 onwards. Public district land and land from DLLRO.
Ferries should be settled by the district land and land reforms by public auction. To be held at least 3 months before the so and so. Constitution to be reviewed parts so and so. Roman 2.
Ferries land reforms act কি ডিফাইন করছে ferries land reforms act কবে থেকে আবার ফেরি করছে হ্যাঁ ফেরি আছে ল্যান্ডের ডেফিনিশন land reforms এ ফেরি আছে ওভারল্যাপ করছে খাটনি বিশাল পরিশ্রম দুটো এক স্ট্যাটিউট ওভারল্যাপ করলে কোনটা land definition of land in Land Reforms Act also covers ferries, has been introduced.
Yes.
Land Reforms Act may have a bearing on this.
Of settlement relating to lands, it is governed by section 49 of the Land Reforms Act. Any kind of section 40. Settlement of lands.
Thank you.
But that's 49, section 49.
তুই আগে বল তবে বলবো না
Thank you. Yes, so what happens if there is a conflict?
I shall go by the order impugned.
Quotes the Panchayat Act as well as this
manual. If your lordship just
the two contradict each other.
I have shown to your lordship the order impugned twice.
110 bold letter are all. I mean, not we should not.
I think, Mala, this is the ultimate decision of the district magistrate. If your lordship kindly just for my pleasure, if your lordship kindly come to the order impugned.
Yes.
Page 132. The third paragraph says the act of settlement is irregular and constitutes an overreach across jurisdiction as per Rule 218 of the West Bengal Land and Land Reforms Manual. It is categorically stated public ferries and non-public ferries, which have been declared as public ferries under the Bengal Ferries Act, shall be exclusively under the control of the district magistrate, subject to the direction of the commissioner. It is pertinent to emphasize that the statutory use of the shall, which denotes so and so. Then, moreover, as per section 110 of the West Bengal Panchayat Act, the management and opinion so and so, so and so. In the absence of explicit cabinet approval, the said settlement stands contravention of the so and so. But in this case, my learned friend may argue the point. I shall give reply so that it will be better, because he has never raised this point at any point of time. So far, maintainability and act are concerned.
But you have to deal with Rule 281 because that is mentioned in the.
Yes, that is mentioned. Let him not argue the case. So for this part is also because he has, that is there. I should have made myself ready. But if there is a conflict, my lord, I have to go through the same also.
Would you like to come more prepared, Mr. Shah? You can take up the next. That would, because this you cannot do it externally. You have to also look into the conflict between two acts and what will be the position.
Yes. So sometime
land definition of land includes ferries in Land Reforms Act. We just not notice.
Land and Panchayat Act also have to consider.
If that comes in, then 60, 62 as is
understood,
and 49 as Mr. Shenudra says. So all these read together, what will be the effect?
Ultimate effect.
Patently contradictory to each other.
I'll just give a fair bit of idea that how I'm going to place my submission.
Better for me also.
There are two provisions in Land Reforms Act. One is settlement, another one is management of lands. Settlement comes under section 49 and section 52 deals with the management of lands. This is coming under chapter 8, that is section 52. This is managing the land, not the settlement. Section 49 deals with the settlement and section 52 deals with the management. And to implement this section 52, Rule 28A of the West Bengal Land Reforms Rules has been framed. And my lord, along with that, my lord, I'll be relying on rule-making power, that is section 60, that is power to make rules, as also the section 62, power to state government to give directions. And I'll come up with the notifications that 1991 manual is the product of section 62. Nothing more than that. Section 62 deals with the power of the state government to give directions. And clause 9 of the land manual 1991 says that DLRS, Directorate of Land Revenue Service, has the authority or power emanates from West Bengal Land Reforms Act. And let me take manner to Rule 28.
Definition of land, as you said, includes.
And definition of land 27 also includes.
That is so.
Ferries.
Yes. Manual, it stated that.
I'll come with the notification. I'll come back with the notification
and an advance copy to Mr. Shara so that he can deal.
And all amendments in the manual is quoting section 60 and section 62 of the West Bengal.
But the main manual does not quote anything.
Yes, I'll come with the original notification, copy of the notification, and all subsequent. I have the copy.
The copy of the notification which gave rise to this manual. Give all copies to Mr. Shara, and Mr. Shara, if you want to rely on some other notification, give copies to him.
Source of power.
Source of power on everything. I mean, if you want to rely on anything, just give. This is on source of power.
Yes.
Because manual, how far manual is binding, this question that this goes to the next level then. The interplay between Land Reforms Act and Panchayat Act. So, which is the special statute in this context?
And my lord, I'm making myself clear, my lord. All the two notifications which have been relied by Mr. Shahara is talking about in the year 1979. Another one is 1987. And my manual and all the amendments I'm talking about 1991 and later.
It is not your manual.
I'm sorry.
All our manual. And next time when you use some packing paper from in which you receive some gift in binding your books, please don't use it in court.
These all have been superseded.
Yes. Must be Mr. Bhattacharya's.
No, no, mine.
Your. Very good. What did you get in that? That originally that parcel, what was there? From where you took the packing paper? To bind the book.
এই আর্গুমেন্ট গুলো তো লোয়ার কোর্টে করলে আমি রেডি হয়ে থাকতে পারতাম, তখন তো কিছু বলছি।
Hard in part for further hearing on when should you keep it next Thursday then?
Yes.
For further hearing on December 11, 2025.
There is an indication in the
Under the same heading.
previous order that they will not proceed in the meantime. Like
Yes,
that.
Mr.
This assurance.
So don't proceed in that. Don't.
Yes. We are still on that. It's a dispute between two functionaries. So that's why we are not proceeding.
And another question, my lord. Out of 6, why single one?
No, I have all the
You didn't get. They have.
for other petty guys.
মানে আমাদের পঞ্চায়েতের।
ছাড়াও তাদেরটা ছাড়াও
With a vengeance. So they will also be coming to you. Start contacting them, Mr. Shah.
Sorry, can it be adjourned for 15 days, my lord? Let them come. No. Too fast.
Yes.
Item number 7 with 8.
7 with 8.
Applicant, my lord. Petition applicant.
চলবে এখন চলতে ওরা চলে আসবে অন্যরা চলে আসবে
There are two appeals, my lord.
Yes.
Has been filed by me and cross appeal has been filed by my lord.
Right there. All right.
বাবা দাঁড়া না বাবা
My lord, I am appearing on the requiring authority.
my lord,
Who is the main contesting party?
yes, state. My lord,
State and you are contesting primary and you are the requiring body.
I am the requiring body, my lord. State
petitioner respond.
So you are selling in the winds of the state, obviously.
Obviously, my lord. Obviously.
My lord, kindly here, my lord, kindly read the my lord impugned judges.
My appeal আগে আমাকে বলতে দাও।
আমারই তো অ্যাপিল।
আরে appeal তো আমারও আছে, তুমি পরে করেছো, subsequent appeal তোমার।
আরে দাঁড়ান আমাকে বলতে দিন, আপনি বসুন আমি বলে
Why should he sit? Just because you are saying?
My lord, my appeal is MAT 1540 of 2018. MAT 1540 of 2018.
Yes.
This my lord, kindly come to
একটাই তো পেপার বুক হচ্ছে একটারই হ্যাঁ এটা তো
Mine is 187, my lord.
তো 187 এর একটা
but my lord, I think my lord, something has to be my lord.
What order has been passed?
Yes, my lord,
let us hear from him what order, then we will decide.
My lord, so that my lord, yes.
So you are challenging which part, and you are challenging a part and
entire part.
You are challenging the entire.
What I am saying, I am order although has been passed in my favor, but I am also asking for further thing, my lord, because land has not been used for the purpose for which purpose they were.
So let us hear their appeal first.
I am also asking for restitution of my land, or also, and
okay,
also
then your appeal is dependent on their appeal.
Compensation, my lord.
Well, since their appeal is wider in scope, they are challenging the entire thing. Let us hear them first. If you set aside, then everything goes.
Thank you.
Right.
My lord, kindly come to stay of that my lord appeal, page 24. এই স্টেটা দিয়েছেন জোসেফ 1540 ওটা দিয়ে দিন জোসেফ
1540 is a thinner one. You don't have the paper book?
My lord, may I interrupt one thing, my lord? One thing, my lord.
Have you got the paper books or not?
No, I have got the paper book, my lord. One thing I was required to show, my lord, which my narrative I probably will not show you to your lordship, because this matter was, when appeal was preferred, this matter was heard by Justice Homen Singh, my lord. And he appeared at that point in time. Order was passed. Kindly come to the page 256. The fatty one, my lord, bulky one. Part 1. My lord will find.
Yes.
From the penalty paragraph, my lord.
Yes.
Mr. Sushovan Sengupta, learned advocate appearing on behalf of the state, is requested to take instruction in the matter as to whether the land in question, that is my land, my lord, is in possession of the respondent
257 again, ma'am.
Yes.
Direction is passed in view of assertion made
Yes,
by
for
the-
numbers 4 and 5.
Yes, ma'am. The direction is passed, yes, ma'am, 4 and 5. I'm grateful, ma'am. The direction is passed in view of an assertion made by me, made by the requiring body, namely BSNL, that the land in question was never in their possession. The Mr. Sengupta shall also produce a necessary file with regard to acquisition proceeding and produce the document to show that the present status of the said land.
They are the requiring body. BSNL is the requiring body.
They are the BSNL is the requiring body, and he is supposed to produce the document to show the present status of the said land, my lord. Thereafter, it appears by the communication dated 22nd June 2001, addressed to the land acquisition collector Howrah and the special.
Oh, not handed over to them.
Yes, had categorically said that in spite of repeated requests, the possession of the land in question was never handed over to Calcutta Telephone, and a further request was made to the state authorities to hand over the possession of the said land, as the said land was urgently required by the Calcutta Telephones for a long time. It does not appear from the record that any communication was made by the authorities concerned thereafter. It is necessary for the state authorities to file an affidavit disclosing.
Yes, Mr. Shenmue, you have to file an affidavit.
They have to file, file an affidavit disclosing the document.
Yes.
May I, because what I will make, the submission will be made on my behalf to the extent that is a pure question of law. Only
you are directed specifically, you are present.
Yes.
It is necessary that the state file an affidavit.
Yes, I will.
I will file within 10 days. You have to file within 10 days.
They haven't done.
My lord,
the affidavit, how can you share it, Mr.?
Yes, my lord, since the matter, my lord, I subject to my lord's again kind approval, my lord. I think, my lord, yes, my lord, that is one other thing, my lord. I will come with that, or I will bring the records. My lord, only one thing, Kelly, what I am on for the present appeal, my lord. Absolutely on the base of the pure question of law.
Even then, bringing records.
Yes, I will.
Bringing records won't help because all would not have copies. If you file affidavit disclosing the documents, that will be easier for us. All will have copies then. And with a copy to BSNL also.
Yes, my lord. That is order.
Yes, my lord. Yes, I will.
Apparently, they don't know that they're in possession. So, you have to give a copy to them.
But my lord,
one will not show my lord. That is why I'm interrupting him. I have shown to your lordship. This was the order passed by.
What was done by the impugned order? Tribunal against tribunal. What is this?
No,
single judge.
My lord, single judge. My lord, kindly consider one thing. My lord, may I? My lord,
here what is the appeal about?
Yes. My lord is hearing the appeal.
Let us see.
Yes. May I kindly come to page 24 of the, my lord, the impugned order.
No, in the paper book, which page? Your paper book? Thinner one?
Thinner one, my lord.
He doesn't have a paper book even, Mr. Page 58, man. You don't have a paper, except you, everybody has a paper book.
No, paper book. Junior.
Come with the affidavit and the paper book.
Yes, well, I
can't hear it like this.
Well, kindly, for the timing.
No, stop, kept.
Well, paper book, my lord.
Appearance will be recorded, we'll pass an order.
Yes, my lord.
I pointed out by learned counsel for the appellant in MAT 187 of 2018 that as per previous direction of a division bench of this court, the state was required to file an affidavit disclosing certain documents. However, such affidavit has not yet been filed. The state is directed positively to file such affidavit with copies to all the other parties. Within how much time, Mr. Shenmue? Already 10 days were given long back.
My lord, I'm leaving it to my lord, because my lord, only what I am on, my lord, kindly because
a fortnight then,
because kindly direct the appellant hearing, my lord, to supply those two paper books, because I think, my lord,
that will do.
Yes,
within December 15, 2025, you'll give advance copies to them. The matter shall next be listed on December 18, 2025. You don't have the paper books, your junior must have.
I think here.
I will not be in town. 15th or 16th, my lord. After 16th.
18th just a fixed.
18th. Oh, sorry. Then it's all right. I will be there.
That copy may be served, my lord, so that, my lord, I think it
was served, my lord.
Lost. Junior lost.
Take it from the department. Must be there in the department.
Yes, my lord.
Kindly,
you for furnished copies, he'll pay for the Xerox.
Yes, that can be done. Let there be an order, my lord. Otherwise, no.
You are supposed to be prepared with the paper books.
দিয়ে দেবো হয়ে যাবে আমার advocate record বলে দিয়ে
He'll give it.
no he needed to go to
We are
pay
sure
anything.
he'll give it.
He needed to go to pay anything, my lord.
But we want to see the receipt that he has paid.
Yes. That will be done, my lord.
Obliged.
দিয়ে দাও
But one thing, the requiring body
You are
handed over the money to the state authority.
Position was complete, award was passed.
Let us see the affidavit come because the copy will be given to you also.
My lord, better, my lord.
You can also answer that.
My lord, may I submit in my humble way, my lord, I am submitting that instead of preparation of the affidavits, my lord, I will bring the records. They will make inspection.
We won't be sharing records between ourselves. Put it in by way of an affidavit so that all of us can have a copy when you're here.
Obliged. 7 and 8, my lord, the same.
7 and 8 together, yes, taken up together only.
Yes, analogous.
Great.
Item number 9.
9. What about the respondent, Mr. Banerjee?
Today they are not here.
It is start piecemeal hearing.
Yes. My lord, before my lord going to...
Anyway, it appears from the courtroom that none of the matters, both sides are there. So you can very well start.
Yes. At least
Here
I
to us,
start.
they are not appearing. You start. You are here, you start.
My lord, before going through the impugn order, my lord, in nutshell, I am saying the facts. In the year 1981, I applied for a lease whole land, and the Department of Urban Development, they ultimately given formal offer letter for allotment. And there was a provision that you have to pay by that time 50%. There is a balance 50% they will, by this way from...
This is which area, Mr. Banerjee?
It is in the area of Bidhannagar, Salt Lake.
Bidhannagar, very. Yes.
Thereafter, my lord, what happens, ultimately, the Reed Court found that the allotment, when the allotment was made in my favor, I was the main, only one point. I was a minor. And I suppressed that. But the record says that I clearly stated that I said my date of birth. I stated that when they have required documents and my income certificate, state that I am a minor, I am giving my salary, father's salary certificate.
Would a minor enter by himself into an agreement?
It was no agreement is there, only allotment, and thereafter the provision was there. After the payment of the consideration money, whatever is there.
Were you represented by any next friend or guardian? No.
Not represented. Now question comes that by this time, when the allotment was cancelled, long after, in the year 2007, from 81 it started.
Can it be validated? Even
Yes.
the inception, it was wrong.
It
could not be given to a minor. Allotment could not, in the name of a minor, is not permissible.
Well, only thing is
minor
that
cannot enter into it. This is a sort of a contract because you agree to pay some rent.
Learned Judge, my lord, held that it is the Section 11 of the Contract Act is a void. According to my respectful submission, that allotment cannot be a contract, not an agreement.
There are bilateral the duties.
Bilateral duties.
It's like a lease deed sort of.
But no contract as yet, because I will show.
Show us the allotment itself.
Yes.
We'll decide for that.
Before that, my lord, kindly see, my lord, very few relevant date, then I am going to. My lord, kindly come to page number 42 and 45. Then I am come to the 42 and 45.
Minor to age of consent. What was your age at that point of time?
That point of time, 12 years or something. And kindly see page number 42. This is the letter. I said, my lord, in the paragraph 3, the date of birth is 21st November 1968. It is not suppressed. My allotment has been cancelled in the year after taking all money. They have taken money in spite of knowing that I have a minor. They have taken the salami, initial amount, entire salami. Even they have taken the delay penalty, interest. They have taken everything. They raised the demand, I paid it by challan. After that, whenever this is this case, by that time I became a major. And when
your father was a major.
Father was a major. Father is not father's land.
Major in every sense. That's why you got that allotment. Rightly cancelled.
That is another aspect, my lord. I'm just
another aspect.
I am just confirming.
12 years old, you got an allotment. Allotment means you also agree to pay certain amounts for that.
I have paid.
Yes, that means it's an agreement.
No.
There are mutual liabilities.
I will show
allotment is not unilateral.
I will
that
show
I
my
allot in your name.
Yes.
Bus over. No.
I will show, my lord. Subject to correction, I will show. But kindly
You
come
should
to
quote before the authority sufficiently.
kindly, my lord, kindly come to, my lord, page number 42 and 45.
Yes.
Nothing is required to be submitted because it is
Yes.
checkered history. Otherwise, my lord, there will be miscarriage of justice, my lord. That is why I am showing. I did not suppress. Kindly come to page number 42. I have clearly stated, it is my application. I stated that date of birth is 21st of November 1968.
See, it's not an offense, not your offense. We are not speaking that you are guilty or something like that.
No.
But in law, it is not permissible.
That is one aspect.
The state, even if you disclosed, the state did not have the authority to give it to you. Enter into a contract with a minor.
Okay.
So this is not that you had suppressed or something like that.
No.
Because of your suppression, it has been cancelled. Not only that.
That has been stated.
Maybe stated, but it's a void contract have been issued.
I am trying to convince because I will place my argument that
void have been issued.
Allotment is not an agreement. Allotment is not a contract. Number one. Number two is that this was revived because of the delayed payment of the salami amount. There was a demand raised that you pay the balance amount within time. Before that letter, another, if you pay, your contract will be renewed. It will be revived.
What would be revived?
Your not contract, your allotment will be renewed, not contract. I'm sorry to misquote the word. My allotment will be renewed again.
Contract
Minor, kindly come to
allotment is renewed.
It is renewed, revived. Allotment, kindly come to page number 105 of the paper book. 105 is their letter from the department itself. Now, kindly see that there is a typed document also. It has been typed.
A prayer for extension of time for payment of balance salami.
Balance amount that has been.
It is an agreement to pay salami and then they allot you.
No agreement. As for the terms of the allotment, it is an offer. Allotment. My submission is
offer.
Offer. This is not a binding contract. No binding contract because the contract.
If it's an offer, it's not a binding contract. You cannot enforce it.
No, I'm not enforced. After that, my lord.
Cannot be enforced.
Let me, my lord, place the case, my lord. Let me, my lord.
If it's an offer, it cannot be enforced, Mr. Banerjee.
No, it will be there.
It can only be enforced if it's a binding contract.
My lord, kindly go through the document, please, my lord. Kindly come to page number 145. I'm reading from
145.
105.
Yes.
One of the typographical part, if I read, my lord, it will be better. Legible. 105 capital A.
105 will do. Yes, please read.
With reference to your letter, so I am directed.
But your client will impose cost on this client.
Why, my lord?
This is why you are asking.
I do not know. Is it my fault?
No, not your fault at all. Your client's fault. And you are asking a question to court. That is your fault, Mr.
No,
you cannot ask why.
I apologize for that. I apologize.
Will impose cost because this is a travesty of justice. Because this is patently a contract. And you're wasting court's time. That's why your client, not you. That is the reason. Please read out loudly so that everybody in the court can hear what is in this document. This is a travesty of justice. Because he was the son of an ex-MP and ex-MLA, this was given to you. And you write that in your offer letter. You had the guts to come to courts with this. I, Somar Sengupta, son of Sri Shamsundar Gupta, ex-mayor and ex-MP, have the honor to request you to kindly allot a plot. You write to the authorities saying that you're the son of an ex-mayor and MP. So what? Court cares a fig. You may be a son of whoever. And you are a 12-year-old boy, you are given a allotment by these authorities who are corrupt. People like you breed corruption, Mr. Banerjee, your client. That's why we will impose cost. And we will impose cost because your client is arguing that this is not a contract. Please read out page 105. You are reading this, please do that. That is the reason we will impose cost. Do you understand now? Please read out. Why?
This is my lord.
This is the reason. We have given you the reason why. Now please read out the contract.
It is my lord.
Please place it.
Don't, my lord, take it, my lord.
No, you have answered your why. Now please continue with this. Don't waste time.
My lord, I will show, my lord.
We don't have time for these sort of litigants. Please close your arguments quickly. Yes.
My lord, however, after careful and sympathetic consideration of
So you are reading page 105.
05 capital A, typographical words. This is department's letter. That is
What,
why-
however? Does not start with how. It does not have any however.
To a letter dated, so I am directed.
Read from the beginning, please.
I am directed to say you that.
Read from the beginning, from sir, madam.
Sir, madam, Samur Sengupta, care of Swan, prayer for extension of time for payment of the balance salary beyond the stipulated period, and thereafter allotment order number so and so dated
Yes.
31st of.
Read from sir, madam, from the address with reference to your letter.
With reference to your letter dated 1/4/87, I am directed to say that as you fail to pay the balance salary within 3 years from the date of
Use the microphone, Mr. Banerjee.
offer of allotments under reference.
You say that I am directed to say that as you failed to pay this balance salary within 3 years from the date of offer of allotment. Please carry on.
Offer of allotment order under reference, the said offer stands cancelled as per the terms of the condition. However, after careful sympathetic consideration of your difficulties mentioned in your aforesaid letter, I am directed by the order of the governor to any that the governor has been pleased to my lord, there is some type of mistake. Please to
read from the original.
Please to decide that the offer of allotment under reference will stand revived on your making payment of the balance salary amount in the prescribed manner and submit the received challan within 60 days. Now, before this letter was issued dated 14th of December 88. I paid the balance salary before that. My lord, I paid the balance salary not before that. After that, 26th of December, 60 days time was given to me. I paid the balance salary on 26th of December 1988. That is in page number 55. Kindly come to page number 55. Here is the, my lord.
Yes.
They received with thanks of Samur Sengupta. It is the balance amount of 20,000 balance salary of, this is the plot number AP 390 sector 3. This is the plot. I have paid the balance amount. After that, there was an delayed interest was charged upon me. I paid also that. That is paid. My lord, page number 58. This 16,506 interest on delayed payment. This is challan. This was paid on 10th of January 1992, as it appears from the list of dates. That is, will be revealed from list of date was prepared by another advocate. My lord, it is kindly come to page 131 because maybe there may be some confusion regarding the date. 10/1/1992. Well, kindly 131 is the list of dates along with the appeal petition. It was filed.
Right.
10th of January 1992.
So this may not be a correct list of dates.
This is the correct list of dates, and this was paid.
Yes.
After this payment was made, this the land manager of this department, in the year the thing was going on. It was exchange of correspondence.
Ultimately, allotment was made in your favor.
allotment was initially made. It was kept pending for allotment was made. For the payment part was going on.
So you paid, then the allotment was finalized.
I paid the entire amount as per the allotment.
You have paid, but where is the finalization of the allotment?
I will show the order of allotment first. That is in page number 47.
Yes, 47.
Page number 47, my lord. Very illegible. I have typed it. Got it typed, my lord.
All right.
This is the conditions that I am reading it. It is important, my lord. Reading it. With reference to your application for allotment of a plot of land in Salt Lake City extension scheme under this government, I am directed by the order of the governor of the West Bengal to state that a plot measuring about 4 kata more or less in sector 2 or 3 of the Bidhan Nagar Salt Lake Township may be demised to you on lease of 999 years, subject to the following terms and conditions. The plot will be available on the lease for 999 years on payment of a premium of salaries charged at the average rate of 10,000 per kata. Provided, however, you will have to pay the extra charges for locational advantages, if any additional charges. Then there are certain arithmetical data. I am not going open car parking, these are not relevant. Then B, you are given option to deposit the salami in one of the following ways. Payment of the full amount of the said salami or premium calculated provisionally at the said rate in one installment within 90 days. That I have paid earlier. Within 90 days from the date of this letter, and the balance salami will be finally calculated on the basis of the final actual measurement of the plot and the location of the plot after selection of the same within 90 days. So from the selection, then I will have to pay within 90 days. From the date of the demand, failing which the interest at the rate of so and so for the first 2 years and 10% for the third year. I have to pay it within 3 years. It was the terms and condition in the offer of allotment. My lord, your lordship may kindly see that letter of on the heading letter of offer of allotment. It is an offer. Then payment of the 50% of the salami 90 days from the date of the alignment. Balance salami calculated on the basis of the aforesaid within 7% if the payment is made within first 2 years and 3 years. If you fail to make the payment of the balance sum, even within 3 years, allotment will stand cancelled and the salami already paid to you will be refunded after deduction therefrom administrative charges of ₹50. The amount of the salami deposited to the governor will not bear any interest. The salami or part thereof, as aforesaid, will be deposited with the Reserve Bank of India in the manner by TR Chalan from number so under the head capital quantity of the so Salt Lake scheme. This was this received Chalan will have to be deposited with said executive engineer after the salami in full or part is deposited. Will have to enter into an agreement. Whenever the consideration will be made, full or part, whatever an agreement is required to be done. That agreement, with my information, no agreement was executed. Thereafter, my lord, next page. Check or cash payment of the salami or part thereof will not be accepted. All payment will be made by the deposit in the Reserve Bank of India, Calcutta. On failure to make payment salami within the prescribed time limit mentioned above, the allotment will stand cancelled. Government will be at liberty to offer plot of another. The plot of land will be used exclusively for the residential purpose, for no other purposes. There are taxes and other imposition. No assurance of the completion, development, physical possession of the plot will be handed over before the premium of salami has been paid. Handed over will not be handed over before the premium or salami has been paid in full. Unless I will pay the entire salami, there will be no physical possession. Till date, I am not in the having the physical possession. So far, my instruction is there. After full payment of all the dues, you will have to get the lease drawn up, lease deed executed and registered. This was the scheme of this offer. Thereafter, every time some delays were there. I have stated clearly, first payment I have made within time. Second payment they demanded, I made. There was some delay, but they demanded, as per my correspondent exchange between the parties, they demanded, I immediately paid it within time. Then I paid the interest portion also for the delayed payment. They have accepted it. They did not refund anything, and thing is being continued like this. Thereafter, my lord, It starts from 1981, this entire episode of allotment, EV allotment, and 1981, 82, 83, 84, several correspondences made, payment was made. In 2005, I'm coming to page number 65.
Yes.
Letter issued by the land manager of the Government of West Bengal Urban Development Department. I am directed to write you to invite your attention on the above mentioned subject and to request you to attend at the hearing before the undersigned at the office chamber at the first floor of the so-and-so. The following documents should be produced during the hearing. These are the documents. Original document relating to the above plot, proof of identity such as voter identity, PAN card, ration card, educational certificate, etc. So before that, no whisper was made. Till date, no correspondence was made to me, no communication that your allotment will be cancelled. That is for hearing purpose. As you presume that it will be done, my execution and registration of the list deed or agreement, whatever it will be done after the hearing, after scrutinizing those documents. I attended that. Thereafter,
page 66A also.
66A. The matter as stated in the my son. That is I know.
In your letterhead.
That is.
Ex-mayor.
I'm not. That is why I'm not.
MP.
Well, I will.
You write to the authority with a copy to the urban development minister.
With all due respect, my lord.
I mean, I request you to kindly expedite the approval of
I do respect, my lord. I do not go by this letter. This is a bad letter. I do not go by this letter. I am go by the document itself.
All right.
Whether it is legally permissible or not, I'm not going to be influenced by those letters. I'm not placing it, even not showing it.
All right.
Madam, kindly come to page number 66. Then this is the notice of hearing. I have shown to your lordships. 66 is the then my lord, kindly come to page number
66 is the father's letter.
No, that I am not. That is not required at all. 60 all sorts of, my lord, irritation counts there from, I know, all sorts of irritation. Even I place myself in the position to read it, I will also get irritated. I'll also get irritated. It happens. This is our society, my lord. I am not going by that. I will place the law point, how far it is tenable in law or not. My lord, kindly consider page number 67. I made a representation. Myself wrote a letter that in absence of the relevant file, I have asked them, the file was not produced at the time of hearing. I said that I have the honor to state that the said memo has clearly sent by you in the office of the special, but in absence of the relevant file, work of the registration cannot be carried on. This was, I requested them that please place my record. So thereafter the impugn order was passed. My lord, here, my lord.
68 is the impugn order?
Impugn order. That has been typed, my lord.
68A, we are following that.
It is better copy.
Let us see.
My lord, kindly. Whereas the plot of land measuring 4 katas or plot number FE 395 sector 3 Vidyannagar, Salt Lake City was allotted to Sri Samar Sengupta, son of Sri Shamsundar Gupta, P3 CIT Road, and Kolkata 40 under the department order so and so. Whereas Sri Samar Sengupta now uses the name, so that is not required. Sri Samar Sengupta, alias Samar Sengupta, asked to appear before department. Now, my lord, kindly, whereas his date of birth was found to be, whereas his date of birth found to be 21st of November 1968, as per his statement of marks issued by the Council for the Indian School Certificate Examination, New Delhi. Whereas his date of birth was also mentioned that date in his passport. Whereas it appears that when the allotment was made in favor of him, his age was only 12 years 11 months. Thereafter, and whereas the entire transaction was made in favor of a minor, suppressing his age. Only that, and as such, the transaction is void ab initio, and allotment letter offer is liable to be cancelled. This was the sole ground. My question is, I never suppressed. I have shown your lordship's document. They know, if somebody knows that I am a minor, and letter of allotment was issued. Thereafter, payment was taken, including the interest portion. I have paid it, some delay made. By this time, the original offer letter was cancelled because of the delayed payment. It was revived. If the entire thing revived, I can say, my lord, with my due respect to your lordships, that it can be stated as a renewal of the same agreement. It is not a novation of the contract. It is not the novation. This is the impugned order passed. It is the impugned order passed by the department. Then I am coming to the single benches order. After that, writ petition was filed challenging that.
Which page?
Impugned order, my lord, starts from page 117. I am going through the entire impugned order. It will not take that much of time. 5-6 page, I will read.
Yes.
The short question which arises for this was the consideration, how the court came into the conclusion.
There is a question that if this allotment is in the nature of a transfer, then transfer is permissible to minors. Property can be transferred to minors. There is no bar. Minor may not transfer, but a property can be transferred to a minor. Gift is given to a minor, can be.
Can be. My lord.
So if you can establish this was not a contract which you are trying to enforce, but a transfer, let us see.
My full submission is that the order first I have placed, my lord, otherwise submission will be futile.
Yes.
The short questions which arises for consideration in judgment is whether the offer of the allotment made by the Urban Development Department, UDD, Government of West Bengal, erstwhile Metropolitan Development Department, of a residential plot of land of Salt Lake, Kolkata, for short period for the said plot on the 30th of October 1981 is void ab initio, since the petitioner then was admittedly a minor. The first paragraph, my lord, shows the body of the order. It will reveal nothing has been considered. The petitioner argues through Ms. Aurobindo Chatterjee, Learned Advocate Council, assisted by so-and-so. The petitioner was asked to submit several documents in support of the application for allotment and deposit salary in connection with the allotment, which the petitioner did through his father. The petitioner also submitted undertaking for payment of the salary by his father. I have stated clearly, I can produce my father's salary certificate, I am a minor. It is submitted that all deposits or payments connected to the plots were duly received by the UDD without demur. It is also submitted that there was no suppression of the age of the petitioner, since all the particulars, including the date of his birth, which is 21st of November 1968, I have stated it. Page number 42 and 45, was forwarded to a UDD by the father of the petitioner at the time of apply. The counsel for the petitioner also submits that in 1987, when the petitioner had become 1987, I became a major. When the petitioner had major, in other words, attained majority, the UDT called upon the petitioner to deposit the arrear salary. After I got majority, the arrear salary was paid, and the renewal of the offer was again revived. It was revived. And our arrear payment connected to the said plot. The petitioner acted in terms of the said communication by depositing the arrear payment with the UDD, which was accepted. It is submitted that with the raising of the arrear demand by UDD and compliance of the demand by the petitioner at a period when he had attained majority, the purported lapsed allotment stood revived and the contract stood novated. Here, my lord, order, it was my submission, stood revived. Here I will think, my lord, my submission here, if it is novated, again some new terms, unless some new terms, otherwise there is a no novation of contract will come. It is renewal of the contract, in better sense, in my full submission. For the above stated reasons, the communications of the UDD dated 26 February 2007 is impugned in this writ petition. That order I have just shown. 26 February 2027, order passed by the UDD department, is impugned in this writ petition, by which the letter of allotment dated 30th of October 81 stood cancelled. On the ground, as on date of the allotment, the petitioner was incompetent to contract, being a minor, aged about 12 years, 11 months, 9 years. Appearing for the UDT, T.M. Siddiqui, learned senior government advocate, assisted by S.S. Siddiqui, learned state counsel, submits the provisions of the Indian Contract Act prohibit a minor from entering into a contract. It is submitted that admittedly the petitioner was a minor at the time of submitting his application for allotment of a plot. The LOA was issued, letter of offer of allotment, was issued in the name of the petitioner and not in favor of the natural guardian of the acting on behalf of the minor. It is submitted that it is not the case of the petitioner that the natural guardian entered into a contract on behalf of the petitioner with the UDT. It is the submission of the respondent authority. The payment of the salami as well as furnishing all particulars of the petitioner by his father were incidental acts which lost their validity once the contract itself was found void ab initio. The State Council defends the impugned order dated 26th of February 2007, alleging that there cannot be an ovation of contract in a situation where the contract itself is not recognized in law. The contention of the petitioner that the payment of the additional salami and or area payments which were deposited in 87 when the petitioner was admittedly major cannot apply to a void contract. The same contract being void ab initio is incapable of being renewed. So up to this, my lord, the entire thing was based on the suppression of my age, and even my father's salary made the payment.
No, not only that, court also held that if being a minor, you could not enter into a contract.
It is
not only your suppression. In law, you could not.
I did not suppress it, my lord. That is I want
not
to say.
for your suppression. Your suppression is
Law.
a
My law,
superfluous ground.
they have stated.
Even if we hold that you did not suppress.
Court has, learned judge has.
Law, you could not. There could not be an stable against the law.
Learned judge has, my lord, with my respectful submission.
Learned judge has already started saying that it's void.
There is, according to me, my lord, and respectful submission is that on this part, that
let us see. Let us carry on. Page 120.
At this stage, discussion this contract reminds itself the statutory provision under 11 of the Contract Act, which reads hereunder: who are competent to contract. Every person is competent to contract who is of the age of majority, according to the law to which he is subject, and who is of sound mind and is not disqualified from contracting by and law to which he is subject. From a plain reading of section 11, it is transparent that any person who is a minor in law to which such person is subject is not competent to contract, since the petitioner purported to enter into a contract. Now, to enter into a contract, their own entered into contract with UDT at a stage when he was admittedly minor. It does not stand to reason that a subsequent period when UDT proceeded to notify and accept deposit pertaining to the original contract, a void contract would become subsequently legal. When they are saying one hand, they are purported to enter into a contract. On the other hand, saying that this contract is void. These things are harping in my mind. This court thus reiterates that the competence to contract by the petitioner during his minority being barred or void in terms of section 11 of the Contract Act, the contract and the step taken in furtherance thereof, inclusive of any subsequent undertaking, is a nullity. On the validity of the seasoning, as discussed, a contract being void ab initio is incapable of being ratified at subsequent stage or novated. To the mind of this court, contrary to what has been submitted on behalf of the petitioner, the expression, ratification, and novation work as cross purposes, at least when applied to the present facts. Ratification would mean and imply reiteration of the terms of a void contract, and novation would imply giving a new terms to a void contract. Both the above noted principle fail to carry legal basis in the present case. Apropos the above discussion, the court specifically finds the proposition of law relied upon by the learned senior counsel for the petitioner. Reference has been given this judgment, and to be distinguishable apropos the present facts, considering the minority of the petitioner proposing to enter into a contract with the UDT, the voidness of such action cannot be converted into an actionable legal claim on the ground of subsequent steps. In the backdrop of the above discussion, the court neither finds section 62 or 68 of the Contract Act to be applicable in the present fact. The petitioner cannot now argue that the contract related to the extending necessities of life as a minor life to a minor against the reimbursement for such supplies claimed by the person who had extended the necessaries. In support of this finding, this court finds legal substances from the majority judgment, reference so and so. I would add one judgment is quoted. I would add that where the legislature has declared an infant incompetent to contract, has declared his agreement void, and has pointedly refrained from declaring them to be merely voidable contract and from giving him any power of the ratification, it would take very cogent reasons to compel me where I in doubt, which I am not, to admit a creditor by a back door where these are not that much relevant. On the broad principle, expediency is urged. Why should an adult be unable, having reached maturity, to tame a binding promise to pay money he had actually received? To my mind, there is every reason a lender would be able to advance money to an experienced boy, knowing that as soon as the boy became age, the lender could use as a lever to extract a fresh promise and argument that it was a debt of honor and shame him into making a fresh promise to discharge an obligation which he had incurred at a time when so and so he was not capable of judging for himself. On the parity of reasoning, no relief can be extended to the petitioner. Now, my lord, this is the so the judgment, impugned judgment, my lord, of the learned single judge. It has one-sidedly taken that I am proposing to enter into a contract. Number one. So no contract actually has taken place, and section 11 of the Contract Act, that is why is not applicable, my lord, in the present case. My first point. Second point, if there is no binding contract till date of our acceptance, exchange of communication, but there is a whisper in the rather specifically stated in the offer letter that there will be an agreement first, thereafter there will be lease deed.
If there is no agreement, how can you claim what do you claim to enforce?
I am claim to my right is that after
your right crops up from where?
From the payment, entire payment, there is a clear provision in the offer letter.
It was in terms of an offer letter by them. So there were reciprocal promises on your part. They offered you that if you pay salami, then they'll give the.
They will come into the contract. They will come into the contract or
the allotment.
Allotment offer has been made.
Allotment offer means you have to pay.
Is an offer of allotment.
Yes.
I have accepted the terms of the offer letter.
If it's a contract to enter into a contract, that is not enforceable in law. So you are beaten by your own argument. If you say it's a proposed contract, a contract to enter into a contract is not enforceable in law. That is well settled.
I will leave it to your lordship, my lord. On this point, just I can, my lord, assist your lordship. One thing, my lord, if there is no binding contract, suppose there is no, my lord, for the sake of argument, there is no binding contract, what law will applicable? The doctrine of promissory estoppel will come into play. I have made them promise to pay. They have made them promise to handover of the lands and execution of the lease deed. So the contract has not taken place yet, and they are saying that this contract is void. On the basis of that, the entire proceeding has been undertaken by the authority as well as it has been held by the learned judge. No contract. There is no question comes even novation of the contract. Somebody has argued from the side of the petitioner that if there is no
Banerjee, promissory estoppel is a concept of equity.
Equity
estoppel flows from equity and a rule of evidence.
Yes.
Now these cannot override a specific statute. You cannot do indirectly what you cannot do directly. If a minor cannot enter into a contract with someone else, then a minor cannot claim that by dint of promissory estoppel, the same contract which he cannot enter into should be enforced. So you cannot do indirectly what you cannot do directly. your reliance on promissory estoppel equity is on the basis of equity. Equity cannot defeat law. If there is a specific law, equity cannot defeat that. And secondly, what you cannot get directly, you cannot also get indirectly. There is a specific bar in law under Section 11. To overcome that bar, you cannot use equity as a tool.
Well, in my answer, my respectful answer, my lord, what I say in this aspect, that the main thing is that to be looked into from the documents, from the records, it appears that no binding contract. That much I confine my submission. No binding contract. Secondly, I have paid the entire consideration money. Thirdly, one lease deed is required to be executed. Fourthly, my lord, I became a major long back. At the time of
if it was void ab initio, then it cannot be.
And there was no terms in the.
Cannot be regular.
My lord, it is not by not void ab initio because the Contract Act Section 11 says that if I have a minor at the time of getting into the contract, then it is void ab initio. If no binding contract, a minor has knowing fully well the other side, the respondent authority, government authority. He has taken money from me. I have waited, correspondence made, I have attended the hearing, I have produced all the relevant documents. In that,
we can keep it open subject to hearing. As said, we can leave it open to you to make a money claim, and your cause of action will start now when you are from the appeal of whatever amount you have paid, because they have there cannot be unjust enrichment. You're right on that.
No, not only that. Well, if I can,
but you cannot get an enforcement of a promise to allot something to you.
If your lordship kindly permit me, sometime I will place some pages. If your lordship kindly me and few judgments, to so that the conclusion can be drawn for whether the justice can be given in my favor or not. My lord, kindly come to there.
So we'll keep it parted next Thursday.
My lord.
Heard in part for further hearing on December 11, 2025.
My lord.
Thank you.
Gratefully, lordship.
Of matters relating to MLAs and MP, should we?
My lord, I will request you, lordship, not to.
Mr. Banerjee.
That is, my lord,